It's my understanding that there is a stipulation to this report, to the qualifications and to the recommendations, right?
Yes, Your Honor, on behalf of the state. That's correct, Your Honor.
All right, the court will accept the report as evidence. I think what makes the most sense is, Mr. Tucker, I'm going to continue your case in progress, and we're going to come back here on March the 2nd. Officer Martinez is going to be looking for a placement for you, someplace where you can get out of Central Ohio Behavioral Health, also out of the jail, and we'll come back for a hearing on March the 2nd. Do you understand all of that?
Yeah.
Okay, we'll see everybody back here on March the 2nd. The court is going to order that he be returned to Central Ohio Behavioral Health Care.
Back to Trim Valley.
Yes.
All right.
Okay?
Yeah.
All right, I'll see you in a couple of weeks, Mr. Tucker.
All
We're in recess.
right.
Okay, Mr. Graves, I'm gonna put,
Yes, can I please,
okay, is he in? All right, so you're gonna be on here for at least a half hour.
That's fine.
Take it easy. I'm gonna put down an attorney first, gonna help you out here, okay? He'll walk you through it. Oh, I'm judge. This is the magic. You gotta listen.
Hey, officer, is that Mr. Graves that you have before you, sir?
Yes, can I please,
Okay, is he in an okay state to have an arraignment right now? It sounds a little noisy.
We'll give it a try.
Okay, Mr. Angot. Oh, wait, Mr. Graves, can you hear me, please? How are you, sir? Okay, sir, my name is Jill Banky. I'm the magistrate today that's been assigned to hear your arraignment and conduct your arraignment. So I'm going to put you, can you hear me? Okay, Mr. Graves, I'm going to put you in a breakout room with an attorney by the name of Mr. John Angot, okay? And Mr. Angot's going to explain to you what is occurring today. And then when you're done talking to Mr. Angot, I will call you back here by Zoom and conduct your arraignment, okay? I just ask that you give your best efforts and try to speak with Mr. Angot and give him your cooperation so we can handle your hearing today, okay? Can you try to do that for me, sir?
Yes, brother.
Okay, just try your best, okay? Take a deep breath. Okay, don't speak until you speak with your attorney because I don't want you to say something that might prejudice your rights, okay? Everybody's here to protect your interests. So, Mr. Angot, I'm gonna assign you to room 1. With the Royal Oak Jail, please go to room 1 and assist the litigant. Thank you.
Thank you, Your Honor.
Jeez.
We have money from JIS. If you could ask him what's ticket.
Wait, what are you doing? McLean?
I see in your docket.
Are you talking about, am I looking at the, Mr. McLean? Mr. McLean, can you unmute yourself kindly?
Hello,
Hi, how are you, sir?
I'm all right. How about you?
Can you tell me your legal name? Is that your legal name on the Zoom?
Yeah, James Clay McLean III.
Okay. Do you know what kind of matter you're here on or what you're appearing for? Because I don't see you on my docket.
It was supposed to be for a
Like a pretrial or something, maybe?
like a hearing.
Okay, do you know if it's your first hearing with the court or like a second or third hearing? Because you might have to be before the trial judge. You might be in the wrong Zoom.
It did get reassigned like one time.
Okay. Do you have a ticket number or a case number? This is my docket. You don't see it. Okay. We just don't see your name on the docket for today. So I want to make sure we have your right legal name and we can direct you to the right place.
Hold on.
Okay, while you're looking, will the person who just joined the Zoom as Shanna Matthews, please unmute yourself and start your video. Okay, are you Dion Terrell Matthews?
Yes.
Okay, good morning, sir. I'm going to rename you on the Zoom, and you're going to go into a breakout room with assigned counsel, Mr. Patrick Gagniak, and he's going to talk to you about your case. When you're done talking with him in confidence, you'll come back here to conduct the arraignment. Okay, so you're going to get an invite to go into a breakout room. Counsel, if you could please go to room 2. 1 second, I'm going to make Patrick a co-host.
Sounds good. Thank you.
Okay, thank you. And Patrick, if kindly, counsel, if you could go to room 2, and Mr. Matthews, if you could go to room 2, I would appreciate that. Thank you so much. Did we find anything for this gentleman?
Yeah, he's got, yes, he has several. So does he have his ticket number?
Okay, sir, do you have the ticket number? Because we show some open matters, more than one open matter with the court, and we want to make sure we get you in the right place.
Is this for Royal Oak or Southfield?
This is Royal Oak.
Yeah, this is the right one then. Yeah, they gave me a second court date in the mail, and this is the Zoom ID they gave me.
Okay, but I'm saying, what does it say on your notice that you're appearing for? Like, does it say arraignment, informal hearing? In the upper right-hand corner. Oh, it's in the-
It just says notice to appear.
Okay, now next to where it says notice to appear, there's a box to the right of that. What does that say? Like 2526?
Yeah, 25RO07928.
And the date.
Very
And and then if you continue looking on the right side, but you go down the notice, does it say the date and time today? So you're looking at the notice to appear and you look on the right and then go look at how I'm saying. What does it say for the?
March 4th. I mixed up the dates. I got a whole different date with Southfield, and I mixed up my papers. My bad.
Okay, so we'll see you on March 4th. Okay, sir? Okay, take care. Be well.
I can't do that, but I'll tell him. Maybe the judge can get credit for me. She might get that personal. You think she will?
We're going to try, Joseph.
Okay. Yeah, please give me 2 minutes, please. Please, can I clean myself up so I won't? Give me 2 minutes before we take care of it.
Okay, okay.
Watch this. I got money on my phone. $11. I got money on my phone already.
Mr. Hangott, do you think we'll be able to conduct this arraignment, sir?
Judge, I believe we will. Joseph is upset. It's more of a medical condition issue that we're dealing
Okay.
with.
Well, we'll try. I'm going to call the case now.
Okay.
1 second. All right, I'll call the case now. I don't have hands. Calling the case number of 2600276. This is the City of Royal Oak versus Joseph Lee Graves. Your appearances, please.
Judge ready. John Angat appearing on behalf of Joseph Lee Graves. Mr. Graves just wanted to make himself presentable. I think. Good to go.
Okay. Are you ready to proceed, sir? Or do you need a minute? This isn't.
Yeah.
Are you ready, sir?
Just about, but ma'am, I have some promethazine in this facility, and I need a dose because I'm only taking every 10 hours or 6 hours, and now
Okay, 1 second, sir, because you're in the Royal Oak Jail and I'm in the courtroom with the device. I can't understand everything you're saying. It just is not translating well. But I just want to I just want to give you a warning. So just answer the questions that I ask you, or if Mr. Angat asks you, because you're a defendant and you have some constitutional rights that we want to protect. Okay, so we can get through this, but you're just cooperate, and it's going to be kind of a question and answer, mostly through Mr. Angat and the court. And then if we need to ask you something, we will. So can you grant me that courtesy and try to do that during this hearing, please? Okay. So this is, I'm going to call the case again, 2600276. This is the City of Royal Oak versus Mr. Joseph Lee Graves. Your appearances, please.
Thank you, Your Honor. John Angat appearing on behalf of Joseph Lee Graves.
Okay,
Joseph.
Joseph, tell your name. Now he's listening. Oh, okay. They didn't mute him, did they?
Yes.
Okay, there you are. Sir, I just want you to tell me your name.
Joseph, come up. She
Okay,
can't
just
back there.
okay, just tell me your name, sir.
Great.
Good morning, sir. Thank you. Mr. Angat, today's the date and time set for the arraignment. How would you like to proceed today, sir?
Judge, I did advise Mr. Graves of the charge, the possible penalty. I advised him of his constitutional trial rights. And based upon that, I would ask the court to waive formal reading and stand my client mute.
Okay, based upon those representations, the court will waive the formal reading. Defendant stands mute. A not guilty plea shall enter on his behalf. Is assigned counsel requested for this gentleman?
Yes, Your Honor.
That is granted. Counsel shall be assigned. I got a chat from you on the address. We have a Madison Heights address. Did I get a chat from you or another attorney? Let's check.
That's another attorney, Judge.
Okay.
Regarding Mr. Graves, what he indicated to me is that he has been staying at a shelter at 13 Mile and Crooks. And I'm not sure which shelter that is because
Okay, 1 second. All right. Hold on. 13 and Crooks.
Joseph, can you tell us again where you're staying?
Yes, what do you need me to do, sir?
Okay, where do you stay for the time being so that if we had to send you mail, we could send it to so that you could get it?
You have now speak, please.
Okay, what?
Yes. Yep.
Did you understand my question, sir?
Yes, the shelters are 1717 West 13 Mile Road between Woolworth and Crook. I've been there for over 3.5 months. I've stayed out of trouble.
Okay. You know what? That's commendable. Okay. We all have hard times in our life, and the most important thing is that we get through them. Okay. So this is what I heard, Mr. Angat, and the gentleman court officer, if you can confirm, I heard correct. 1717 West 13 Mile Road. Is that what you heard, Mr. Angat?
It is what I heard, Judge, and what I wrote down.
Okay. Do you have a phone number, sir?
And Judge, I'm looking at it online. Okay. There is, in fact, that is a correct address for, it's called Winter Shelter Services.
Okay, thank you.
And there's a phone number there. I don't know if we want to put that in the file.
Yes, please.
248-850-3219.
Okay. Thank you so much for that assistance. Okay, sir. Mr. Angot, the next part of the arraignment, now that we have the plea and contact information and assigned counsel, would be bond and bond conditions.
Judge, I think it's pretty clear that unfortunately, Mr. Graves is in a position where financially he cannot post any kind of bond. Just looking at the charge itself, it's certainly not a crime of violence that's being alleged. I don't know if he has any kind of capious history. I don't have those records, but we do have an actual address that he provided, and it's a valid address. So I'd ask the court just to consider a personal bond here, and hopefully we can get him through this matter.
Okay.
Right.
1 second, please.
Yes. Right. Judgment. I don't want no chip. I don't want. I want my medication to know you. I really do need my medication. God, I'm not doing this stuff right. He does everything I go to the shelter. And I want you to visit me at the shelter because you.
Okay, the court is going to set a $5,000 personal bond with the following conditions, please. Okay, sir, I'm telling you what the conditions of your release are, okay? There's no money due at this time. You have to personally appear for all court appearances. We're going to send them to the place on 13 Mile Road where you're staying. You have to abide by any judgment, enter in this case, surrender to serve any sentence imposed. Do not commit any crime while released. You have to notify the court in writing if you leave the winter shelter services and if you stay somewhere else. And do not enter upon any Corwell or Beaumont properties. Okay, that includes the hospital and any medical buildings. Okay. And those, if they're in Royal Oak or Berkeley. We'll set this matter for a pretrial.
Can we go a couple months from now, please? I won't get in trouble, I promise.
Okay, I like that promise. No more. You can't get in trouble anymore while you're out on pretrial release. So I'm going to take you on your word for that. You can't get in any more trouble. It looks like you understood the conditions of your bond. We're going to set this matter for a pretrial. You have Judge Meineke. The notice to appear will be sent to Winter Shelter Services address, and you will have assigned counsel. Mr. Angot, is there anything further requested or required of the court on behalf of Mr. Graves?
Judge, I thank you. Nothing further.
Okay, thank you. Mr. Graves, this concludes your hearing. You're going to get some paperwork. You better obey the terms of the bond because you don't have to post any money. So get it together, okay?
Over the precinct.
Okay, thank you.
You do, Your Honor?
Thank you.
Thank you, Your Honor.
Okay, thank you, Mr. Angot. Nothing further for Mr. Angot, right? Mr. Angot, we're done with what we have ready. So if you want to leave the Zoom, we'll call you if we need you. Thank you for your assistance this morning.
Yeah, thank you,
Okay. Let's get back to the docket. I thought I did. I'm sorry, ma'am. Okay, so we have, I lost track, Mr. Gagniak. Hang on 1 second. We have Matthews, and then we have someone named Dion. Okay, Deanna, I'm going to rename you, and yes, you will be able to speak with the attorney before your case is called, okay? Morning, counsel.
Hi, good morning.
Is Mr. Matthews ready, please?
Yes, yes, thank you.
Okay, calling the case number of 2600103. This is the case of the City of Berkeley versus Dion Terrell Matthews. Your appearance, please.
Good morning. For the record, Patrick Agnick on behalf of Mr. Matthews. Mr. Matthews, if you want to state your name for the court, please.
Dion Terrell Matthews.
Good morning,
Thank you for
sir.
that. No
Sir,
no
thank
objection.
you, Mr. Matthews. Thank you for appearing early. Thank you for your professional dress, your attire, and your demeanor. Makes such an impression on the court, and I appreciate your respect for these proceedings. Proceed, counsel.
Thank you. Mr. Matthews, if you want to state your name for the court, please.
Dion Terrell Matthews.
Thank you for that. No objection, handling the matter by video this morning, but I did speak in private to Mr. Matthews just now. Mr. Matthews, you understand what you're charged with, is that correct?
Yes.
Given his acknowledgement, the court can waive any further reading. Request a not guilty plea to be entered. He will make a request for appointed counsel, please.
Okay, so based upon your representations, the court will waive the formal reading. Defendant pleads not guilty. A not guilty plea shall enter. The request for assigned counsel is granted. Counsel shall be assigned for this gentleman. What do you have to say? Oh, wait, contact information. So the Southfield address is a good address, sir?
Oh, correct.
Yeah.
And then I did text both his phone and email.
So
to
give me
the
1
court.
second to catch up, please.
But the address that the court has on the file, that is a valid address.
Thank you. And I'll get the phone right now. Okay, what do you have to say about bond and bond conditions? Is this Operation Drive or not Operation Drive?
No, this was a slight hiccup. There was a misunderstanding. Purchase of a new vehicle. He has since corrected the issue. The vehicle is registered. My understanding, there's no issues with his license. He appeared here timely this morning. I think a personal bond is warranted.
Okay, 1 second. I'm still getting the email address. Okay, the court is setting a $2,500 personal bond with the following conditions, please. Mr. Matthews, you have to personally appear whether by Zoom or in person as ordered by the court. You have Judge Meineke. The next step is going to be a pretrial. I believe the trial judge is still doing his by Zoom. So when you get your notice to appear, it will be before the trial judge, and I'll have a different Zoom ID than you used today to log on because I'm just the magistrate. So when you get your notice, please look at the Zoom ID and log on to the right courtroom. You have to abide by any judgment entered in this case, surrender to serve any sentence imposed. Do not commit any crime while released, and you shall immediately notify the court in writing of any change of address from Kesh Street and or the phone number ending in 0677. We're going to set this matter for a pretrial. The notice to appear will be sent to Southfield. You will have assigned counsel, and as I stated, it will have a different Zoom ID. Is there anything further requested or required of the court on behalf of Mr. Matthews' counsel?
Nothing further. Thank you.
Okay. All right. So, Mr. Matthews, to recap, we held the arraignment. You pled not guilty. You'll have assigned counsel. The bond is $2,500 personal. No money's due at this time. You're going to have to appear at the next in all events, but the next one is a pretrial, and you will have assigned counsel. Okay.
Yes.
Do you have any questions for the court?
No.
All right. Thank you so much, sir. Your arraignment has concluded. You're free to leave the Zoom, or you can stay and observe, whatever your choice is. Okay.
Okay. Thank you, Your Honor.
Thank you so much. Take care. Be well.
You're all set. Good luck to you, sir. I'll be in touch here this afternoon.
Okay. Thank you.
Okay. Patrick, can you please go in a breakout room with Miss McElroy. Miss McElroy, please, Patrick, I'm going to move you to room 1. Miss McElroy, please go to room 1. Well, the person on the Zoom identified is Isadora Ricarte. Identify yourself, please.
Oh, yes.
Are you,
I
sir?
don't know if I have. Hello, good, thank you. I don't know if I have the correct meeting. I joined with, I think I'm with Judge Kowalski, but I
Okay,
joined
let me
the-
give you, if you're with Judge K, I'm going to give you the Zoom ID, please.
Yes, please. Just give me 1 second.
Sure.
Yeah, I'm ready.
Tell me
I'm
when okay, ready? 831
Yep.
029
Mhm.
3441. Ready? 831 029 3441.
All right. Thank you very much.
Okay, thank you. Good luck to you, sir. Morning.
How are you?
Oh, I'm fine, thank you. You had some technical difficulties, but I just asked your counsel and he said that we're okay to call the case. So I got your chats. I'm not ignoring you.
No, you're fine.
Okay. Okay, calling the case of 2600105. Your appearances, please. Oh, I'm sorry. Calling the case of 2600105. This is the City of Berkeley versus Deanna Faith McElroy. Your appearances, please.
Good morning. For the record, Patrick Agnick on behalf of the defendant. Ms. McElroy, if you could state your name for the court.
Deanna Faith McElroy.
Good morning. This
Thank
is
you
the
for
date
that.
and time set for the arraignment. How are we proceeding today, counsel?
No objection handling the matter by Zoom this morning. I did send the court her updated mailing address and phone number. Did speak with her in private. She does acknowledge what she is charged with. I'd ask the court to waive any further reading, request both a not guilty plea to be entered, as well as counsel to be appointed.
Okay, we'll waive the formal reading. Defendant pleads not guilty, did you say?
Not guilty, please.
Okay, a not guilty plea shall enter. The request for assigned counsel is granted. Counsel shall be assigned. And give me a minute to get the contact information, which has been chatted. So let me look at that. Okay, it's apartment 102, correct?
Correct.
And did that have a phone with it?
There was a separate
Yeah, I got it.
text
I
that
got it.
had a new phone.
Give me 1 second. Okay. Thank you for the updated contact information. What do you have to say about bond and bond conditions? And is this a Operation Drive candidate?
It is going to be an Operation Drive case. I did explain that to her. I think that would be to her benefit. She did appear here timely this morning. It is obviously a non-assaultive crime. I think that a personal bond would be warranted in this case.
Okay. Okay, the court is setting a $2,500 personal bond. No money is due at this time. Ms. McElroy, with the following conditions, please. You have to personally appear, whether by Zoom like you're doing today or in person, if ordered by the court, for all court events in this case. And I'm sure as counsel explained to you, Operation Drive is a program in this court we take great pride in. We try to work with the litigants to help them get legally on the road. Okay. And it seems like from a review of your file that you could benefit from our program. So the bonus is we hope that at the end of the program, you'll have a license and then you and I don't have to meet anymore. However, it takes a lot of time and there's a lot of review dates in Operation Drive and you have to stick with the program. So if there is something scheduled with your name on it, no matter how many times you have to come, the condition of this bond is that you appear every time. Do you understand that?
Yes, Your Honor.
Okay, you have to abide by any judgment entered in this case, surrender to serve any sentence imposed. Do not commit any crime while released. That means do not drive without a valid license. And I'm sure you're sitting in a passenger seat in a car and not driving during this hearing. So you cannot drive without a valid license. And if you continue to do so, that's a violation of this bond, okay? You shall immediately notify the court in writing of any change of address from Central Park, apartment 102, and or the phone number ending in 5980. Okay, the bond is $2,500 personal. You don't owe any money at this time, but you do have to appear for everything. So if you skip a hearing, the bond may come into play. Do you understand that?
Yes, Your Honor.
Okay, thank you. And we'll set this matter for a pretrial. You have Judge Meineke, he's the one that set up the program. So he always looks forward to helping the people that appear before his courtroom, but you can only lead a horse to water, right? So it's up to you to take advantage of all the benefits of the program, okay? We're going to set this matter for a pretrial. That'll be before Judge Meineke. The notice to appear will be sent to Southfield. You will have assigned counsel. It'll have a different Zoom ID than you use today to log on. So make sure you watch in the mail. And when the time comes on the date and time, you log on to the proper courtroom. You will have assigned counsel who will be in touch with you. Do you understand all of that?
Yes, Your Honor.
Do you have any questions for the court, please?
I have no questions at this time, but if I do, can I reach out to you via email or?
You would reach out to your attorney.
Okay,
Okay.
will do.
So
Yes.
the only time you can't contact the judges directly, but if you ever have a question about like, do I have a hearing date? I can't appear. Oh, another thing, if you can't appear by Zoom, like you don't have the technology or whatever, you can always come to court and we'll set you up on a device. But if you have any questions in general, you can call the court and speak to a clerk. And if you have specific questions about your case, like legal advice, you call your attorney.
Will do. Thank
Okay.
you.
Counsel, is there anything further requested or required of the court on behalf of this defendant, please? I can't hear you. I can't hear you.
Nothing further. I'll reach out this afternoon by email with my information. We can talk the next steps.
Okay, perfect. Thank you, sir. Okay, ma'am, you may leave the Zoom. Good luck to you. Take care and be well.
Thank you. You as well.
Okay, we don't have anything else available for you right now.
All right. I'm going to
I
put my
have to
screen
go,
down.
just so you know, I have to go on Oakland video at 9:30. So just like if we get an influx of your people, I have to take the video at 9:30.
Influx. We only have 3 left. I think we'll be okay.
Wait, they're all going to appear, woman, maybe Mrs. 831.
Did you get a waiver on 8:30 or is she missing?
Missing? I don't have anything crossed out.
Your perfect day is already ruined.
Not yet. Don't lose faith. All right.
I'm going to actually sign out. I'm going to switch devices. So if you see me pop back up, let me back in.
We'll let you in. Okay. Thanks.
Sounds good.
them, that they actually are going to make it worse than if I do it myself. And I haven't heard you say that. I don't think that's what you're going to do. So I guess I'm encouraging you to reevaluate your position about interacting with these lawyers. You will make their job harder if you don't interact with them when they have questions or when you have thoughts and ideas that you want to share with them. But I don't find that you are facing a situation where you have lawyers who are unprepared, don't know what the case is about, or who haven't made good faith efforts to maintain a relationship with the client. And I'm not going to let you sabotage it so that we don't go forward on Monday. There have been months and months for us to have dealt with this, and it's an interesting coincidence that it comes up now. But I just want you to understand that you'll be back on Monday morning and we'll be going forward, and you're going to be making the adult decision of whether you collaborate with your lawyers or if you sit there sullen and choose not to assist them as they try to navigate the trial. Okay?
I don't have a choice.
I've told you your two choices, and you've told me you're not interested in representing yourself.
I didn't say I wasn't interested. I said I'm not capable.
Okay. Do you want to have the conversation about representing yourself, or do you want to save that till Monday because you're going to think about it more?
I'm not capable of representing myself.
All right, then we'll stay away from that one. And then that says to me, absent someone showing up on your behalf on Monday saying, nope, I'm here for Mr. Hairston, then you understand what we're doing on Monday. Okay. Thank you, Mr. Banks, Mr. McCrimmon.
We go to the back.
Yes. Oh, yeah, we've got that. That'd be great.
And Judge, unless I'm needed back, may I be excused?
Yes, ma'am. We have an afternoon calendar, but I don't think you'll know if you have something on it.
But I'll log on.
Okay, sounds good. Appreciate you being here. Ms. Smith and Ms. Rios, I have to go handle an adoption. It will not take long. I'm going to go back and do that in chambers. It's online as well.
Objection.
No.
Okay, thank you so much. You may leave the Zoom.
Okay, thank you. Bye.
Hi, I'm the magistrate assigned to hear your case today. I just want to let you know that Deputy Koki will be appearing around 9:31, but at 9:31, I have to take a criminal matter on video from Oakland County Jail. So I have to take that case first, and then we'll proceed with Deputy Koki's cases. And when I get to his cases, you'll be the first case to be called because you checked in first. Okay?
Thank you.
Will the person on the Zoom identified as iPhone, please unmute yourself and identify yourself for the court, please. iPhone. Are you here as a member of the public to observe, or do you have a matter before the court? Oh, there you are. Can you tell me who you are, sir?
My name is Desmond George.
Oh, Desmond George. Okay, so you're here for an informal hearing also with Deputy Koki, and he came early, and I told him to come back at 9:30, so he will be here. And I have to take a criminal matter from Oakland County Jail first at 9:30, and the gentleman is here, but his attorney is not, right? Mm-hmm. Okay, so as soon as I'm done with the video matter, then I'll call Deputy Koki's 9:31 cases, and you'll be the second to be called. I see that you have a no proof of insurance, so if you've renewed your insurance and you have documents, make sure you can show them or have them before you for the hearing, okay? If not, then we'll address that during the hearing. Okay, so I just wanted to let you know that you're checked in and you're in the right place, okay?
Okay, no problem. Thank you.
Thank you, sir. Mr. Necco,
Oh, yes.
did I say that? Did I say that correctly?
No, it's Nico.
Oh, Nico. Okay, Mr. Nico, have you spoken to an attorney yet on these two cases?
I think is that what the arraignment was?
Yeah, it's going to be an arraignment and you have two matters. I just want to see if you're going to need to go in a breakout room with the attorney. Who's the attorney? Okay. Have you spoken with an attorney by the name of Donald Andrews?
Yes.
Okay. So as soon as he comes on the Zoom, we're going to call your case. We're a little bit early.
Okay.
Okay. Mr. Gagnac, Mr. Moore is checking in. And here, okay. Mr. Moore? Good morning, sir. My name is Jill Benke. I'm the magistrate assigned to hear your arraignment. You are going to go into a breakout room and speak with attorney Patrick Gagnac about your case. And when you're done speaking with him in confidence, you'll come back here and I'll call your case. Okay? So you're going to get an invite to go to a breakout room.
Okay.
Patrick, please go to room 1 kindly. And Mr. Moore, please go to room 1. Patrick, I've made you a co-host with your new device. Okay. Mr. Andrews, good morning.
Good morning, Your Honor.
How are you?
Good. How are you?
Okay. I asked your client if you had already spoken and he said yes. Do you need to go in a breakout room before we call the cases?
I think we're ready to proceed.
Okay. We have 2 cases. Are you aware of both?
I had a bench warrant for no ops.
Okay. I have a 2-5 case and then I have a new case, a 2-6 case that's driving while license suspended, no insurance, no lights.
What's the date on that?
The date on that ticket is 2/4/26. So it probably was not.
Yeah,
It was set for an arraignment for March 12th at 8:31. So we could do the arraignment on both if you are in agreement.
You'd like to do that today, sir, instead of waiting to March 12th?
Yes, that's fine.
Okay. Your
Would you
Honor,
like to go into a breakout room and discuss the new issues, or are we able to proceed? What's your pleasure?
I did go over with him the maximum possible penalties on the other one. So I think we're ready to proceed.
Okay. So what we're going to do is I will call the old case first, the older case, and then we'll handle the new matter that we're taking early. Okay. If that meets with everyone's approval.
Yes, Your Honor. Mr. Daniel, is that what you want to do?
Mr. Nico.
Or
His
Nico?
last name is Nico, correct?
No.
No,
Your last
yes.
name is Daniel?
Yes.
Okay, I'm sorry. I called you wrong. My apologies, sir. Okay, so Mr. Daniel, I was wrong. Your attorney was right. I sit corrected. The case is 2500826. This is the City of Berkeley versus Mr. Nico Daniel. Your appearance, please.
Thank you, Your Honor. May it please the court, Donald Andrews, P48501 on behalf of Mr. Daniel. Mr. Daniel, can you state your full name again, please, just for the record?
Nico Daniel.
Thank you.
Good morning.
Good morning. Your Honor, I did have a chance to speak with Mr. Daniel regarding the 25 case. We went over the charge, maximum possible penalty, and his constitutional rights. He understands all of those. So for purposes of arraignment, we'd waive formal reading, he'd stand mute.
Okay, so we'll do the arraignment on the bench warrant and the underlying charges on this case because he's never been arraigned. So we will recall and set aside the bench warrant.
Thank you.
And you said waive the formal reading. Defendant stands mute.
Yes, Your Honor.
Okay. And a not guilty plea shall be entered on behalf of this gentleman. Is assigned counsel requested?
Your Honor, he is currently not working, so he would ask the court to be considered for a court-appointed attorney. If he does hire one, he'll let the court know.
Okay, the request for assigned counsel is granted. Sir, are you aware of our program in our court called Operation Drive?
No.
Okay, we have a program in this court called Operation Drive where people who get violations for failure to display a valid license, we put you in this program where the attorneys and the court work with you to try to get you legally on the road. Okay. So I'm not sure if you qualify, but with this type of violation, I'm going to put you in that program to see if they can't work with you. It can be burdensome. It can be a long time because depending on what happens in the program, there's a lot of what they call sentence reviews, and they give you time to go to other jurisdictions and to clear things that may be obstacles to you getting a license. But the court has very learned attorneys. The judge himself is very learned on how to work the systems and with the different courts. So hopefully at the end of the program, you can have a license and then you and I don't have to meet like this anymore. So there's a lot of sentence reviews, but it's really worth the effort. Through the program, we've had over or almost 2,000 people get their license back. And it's become a model for other courts. So if you can take advantage of this, you should. I mean, not having a criminal matter is never fun, but sometimes the best break is getting this ticket in this jurisdiction. So I hope that you will avail yourself of the assigned counsel and being put in Operation Drive. Okay. That being said, I have an address for you on Auburn Street in Detroit. Is that a good address for you, sir?
Yes.
Okay. And do you have a phone number where the court can call you?
Yes.
Could I have it, please?
Yes. It's 313.
Okay.
728 1500.
Okay. And thank you for that. And counsel, what do you have to say about bond and bond conditions?
Your Honor, Mr. Daniel, 22 years old. He does have an address I believe he gave to you. He is not working, but he did ask for, or he applied for a job that he expects to be able to get if he gets out. So we would ask the court to consider that and give him a reasonable bond that would help him get out and be able to take care of these matters. And I would concur with the court's assessment of Operation Drive. That is a very
Sir, are you on any probation or parole right now?
I'm on probation.
Out of what court are you on probation? Do you know which court or city? Redford. Okay. Do you have any financial ability to post any bond on this 25 case?
The money is not looking good, but I was gonna try to see if I can put my car title up, if that's possible or something.
Oh, okay. The failure to appear twice, what was going on in June of 25 that you failed to appear? Were you in custody? Were you?
June 2025?
June, last year, June in 2025 that you didn't appear.
So like I said, I've been so busy during that time, and like I said, I was just collecting tickets and forgetting about them. So
okay, well, why is that a bad habit? Tell me what you learned from that.
I'm learning now.
Yeah, now we're in a big mess, right? We're in a big mess.
Yes.
I don't want to work a financial hardship. You already don't have a license. It's got to be very difficult to make a living with no license. You can't keep driving like this, okay? So you got to go to Operation Drive, and you better start saving up your money to pay your fines and costs, because that's the way out. You know, so you got to make good choices, and you really shouldn't qualify for a personal bond, but in the spirit of Operation Drive, the court, I mean, are you going to, let me ask you something. You have other matters today that you have to clear? Mr. Andrews?
Yes, Your
Like
Honor.
if I post a low cash bond, does that benefit him in getting credit for time served? Or is he going to get things cleared today and a financial bond would prevent his release? Which is the path here?
He's got two other matters outstanding, one in Oak Park and the other in Hazel Park. It's going to be similar. It's similar to these matters. So, I mean, I guess depending on what the court does today, I'll be able to advocate for him if he's going to be in this program, that the court kind of follow what Your Honor do.
Okay, so you want a low cash bond or a personal bond?
Sir, can you come up with anything today?
Like I said, my older brother is locked up, and I know my dad was trying his hardest to get him out, and I just, somehow got in.
Okay, so please make better choices. Your dad's running around like he must be so worried about you guys. Think about your family when you do these things.
I guess I would ask for a personal bond. And,
Okay, the court's going to order a $2,500 personal bond. No money's due at this time. You know what's a violation of this bond? If you drive without a license. So let's get it together. Got a lot of tickets, you got a lot to get organized, but we're going to put you in Operation Drive. We'll set this matter for a pretrial in Operation Drive. You will have assigned counsel. The notice to appear will be sent to Auburn Street. Okay? So the conditions of your bond are, I forgot to read this, you have to personally appear for any exam, arraignment, trial, or sentencing, whether that be by Zoom or in person. As ordered by the court, you have to abide by any judgment, enter in this case, surrender to serve any sentence imposed. Do not commit any crime while released. Do not drive without a valid license. You shall immediately notify the court in writing of any change of address from Auburn Street in Detroit, or the phone number ending in 1500. Okay, we'll set this matter for a pretrial. On the second case now, calling 2500194. This is the City of Royal Oak versus Mr. Nico Daniel. This is, since the defendant is in custody, the arraignment on this case was currently scheduled for March 12, 2026 at 8:30 a.m. But since we have the gentleman before us, we're going to conduct the arraignment on the 26th case with the agreement and consent of counsel and the defendant. Your appearances, please.
Thank you, Your Honor. May it please the court, Donald Andrews, P48501, on behalf of Mr. Nico Daniel. Sir, can you state your name for the record again?
Yes, Nico Daniel.
Thank you. Your Honor, I did get a chance to speak with him. He is aware of the maximum possible penalties of this charge. So for purposes of arraignment, we'd waive formal reading and he would stand mute.
Okay, the court will waive the formal reading. Defendant stands mute. And in the interest of time, can we duplicate everything that was said in the first case and apply it to this case?
Yes, Your Honor.
And may I proceed then to the bond and bond conditions?
Thank you, Your Honor.
I'm going to take what you said in that case and apply it here. So
yes,
I was going to set an identical bond.
Thank you, Your Honor.
Okay, any objection to that, sir?
No.
Okay, do you understand that everything I said in the first case applies to you in the second case? There's two bonds of $2,500 each personal, okay?
Yeah.
Okay, so this is going to be an Operation Drive 2. You got to appear. You got to help us help you. Got it?
That's right? What I need.
Yeah, well, we're here to help. So you got to help us. You got to cooperate. Okay, sir?
Yes.
Okay. That concludes the arraignment on both cases unless something is unclear or has not been handled in the 26th case.
Review from the prosecutor's office. We're here today for a plea hearing. It's my understanding Mr. Bodenheimer is going to enter a plea of guilty to one count of domestic violence as a third-degree felony. Is that accurately stated?
It is, Your Honor.
Mr. Bodenheimer, how old are you?
47, Your
How
Honor.
far did you go in school?
What's that?
How far did you go in school?
GED, sir.
Are you able to read and write English?
Yes.
Are you under the influence of drugs or alcohol?
No.
Are you taking any medications?
Yes.
What are you taking?
Abilify and Zoloft.
Are you taking anything that would interfere with your ability to understand what we're doing here today?
No.
Are you a United States citizen?
Yes.
If you enter a plea of guilty to this charge, I'm not going to sentence you today because I don't know enough about you and I don't know enough about this case yet. What I'm going to do is conduct a level 2 pre-sentence investigation. We're also going to do an evaluation to determine whether or not you're appropriate for a community-based corrections facility. We're going to come back here in about 6 weeks for sentencing. This is what I call an open plea, which means that I have no idea what I'm going to sentence you to. So I think you and I can agree that it would not be possible for anybody to have promised you anything about what your sentence is going to be, right?
Yes, Your Honor.
Has anybody made any threats or representations to get you to plead guilty to this against your will?
No, Your Honor.
I have a document entitled Change of Plea and Entry. On the second page is a signature above the line defendant. Is that your signature?
Yes, sir.
Did you review this with Mr. Staten before you signed it?
Yes, Your Honor.
Are you satisfied with the representation that you've received in the case?
Yes, Your Honor.
You're going to enter a plea of guilty to one count of domestic violence. This is a third-degree felony. It's punishable by up to 36 months in prison and a $10,000 fine. If I do send you to prison, and I'm not saying that I'm going to, but if I did, it also includes an optional period of post-release control, no, mandatory period of post-release control of anywhere from 1 to 3 years. Before we go any further, Mr. Bodenheimer, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. If they can, they have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at that trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to this charge, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the sentence. Is that what you want to do?
Yes, Your Honor.
Mr. Dew?
Your Honor, if the case were to proceed to trial, the state would produce evidence beyond a reasonable doubt that on October the 30th of 2025 in the city of Franklin, Warren County, state of Ohio, that the defendant caused physical harm to Angie Berry, a family or household member, and that he has 2 prior convictions for domestic violence.
Anything on those facts, Mr. Staten?
No, Your Honor. Thank you.
Mr. Bodenheimer, did you hear those facts?
Yes, Your Honor.
Do you admit that they are true?
Yes, Your Honor.
Do you understand the rights you're giving up by entering a plea?
What's that?
Do you understand the rights that you are giving up by entering a plea?
Yes, Your Honor.
Which plea?
Guilty, Your Honor.
Based upon the plea of guilty, I'm going to find you guilty. I think you've made a knowing, voluntary, and intelligent choice here today, only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. We're not going to go into the matter of the sentence today. I'm going to order a level 2 pre-sentence investigation, also an evaluation to determine whether or not you're appropriate for a community-based corrections facility. We'll see you in about 6 weeks.
Okay.
All right, that's all.
Thank you, Your Honor.
Shall be God?
Yes, Your Honor.
Mr. Adu, you're here today for a first hearing on a non-payment of rent case. Have you read the advice of rights form that was mailed out to you?
Yes, Your Honor.
Do you have any questions about your rights after reading that form?
No, Your Honor.
Do you want to speak with a free legal aid attorney today?
No, Your Honor.
All right. Counsel, have you resolved this with Mr. Adu?
Yes, Judge, this will be a consent possession only. 2,137.98 is the total, March 2nd written.
I'm sorry, what was this? What was the total?
2,237.98. And Mr. Addo gave me permission to sign his name to the order.
And the writ was March 7th?
The 2nd, yes.
March 2nd, yes. All right, Mr. Adu, you agree that's the amount of money that you owe?
Yes, Your Honor.
All right. So, Mr. Adu, you have to pay that sum or move out by March 2nd. If you do neither, your landlord can get an order evicting you. You understand that?
Yes, Your Honor.
A copy of the judgment will be mailed out to each of you after it's signed by the court. Each have a good day.
All right. Thank you, Your Honor.
Thank you. We can set that for next hearing will be March 6th. On Zoom, same password, time to be determined. But don't leave till you speak with the court-appointed attorney, all right, Mr. Baines?
Okay. Thank you.
All right, each have a good day.
You too.
Brandon Jones.
Hello.
Good morning.
Good morning.
I have Mr. Yosef here. He's the attorney for Heritage Glen Apartments. I'm going to place you into a breakout room and he will be in shortly to speak with you.
Okay, thank you.
You're welcome. Ms. Bates, I just need you to unmute your device. There should be like a microphone down in the right-hand corner, it says audio. You need to click on that.
Are you able to hear me now?
Yes, I can. Perfect. Thank you. I have the attorney here, Mr. Yosef. He's the attorney for Heritage Glen Apartments. I'm going to place you into a breakout room and then he will be in shortly to speak with you, okay?
All right, thank you.
You're welcome.
This is the matter of Heritage Glen Apartments versus Brandon Jones, 2603290. Mr. ISF, good morning.
Morning, Judge.
Good morning.
And you're Brandon Jones?
Yes, sir.
I can't see you, Mr. Jones.
Can you see me now?
Yes. We're in court now, Mr. Jones. I'm going to ask you to take your hat off.
I have to hold the phone up to my ear to be able to hear you, Judge. I'm sorry.
I can't see you, Mr. Jones. All right, you have to take your hat off. We're in court now. Can you hear me?
I gotta put the phone back up to my ear to hear you.
Mr. Jones, take your hat off. We're in court now.
You mind saying that again for me, sir?
Mr. Jones,
Yes, sir.
take your hat off. We're in court.
Oh, I'll record?
Yeah, we're in court. Take your hat off. Take your hat off.
Say that one more time.
Oh, have mercy.
Take your hat off, Mr. Jones. Let's get it over with.
Mr. Jones, raise your right hand.
What'd you say, Judge?
Raise your right hand. Do you solemnly swear or affirm to tell the truth, whole truth, nothing but the truth, so help you God?
Say that again.
Do you solemnly swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
Mr. Jones, you're here today for a first hearing on a non-payment of rent case. Did you read the advice of rights form that was mailed to you?
Yes, sir.
You have any questions about your rights after reading that form?
No, sir.
Do you want to speak with a free legal aid attorney?
Yes, sir.
All right, we'll put you in a breakout room.
Judge, he's
we have-
confused. He's confused. He doesn't want an attorney. We resolved it. He can't hear you.
I'm sorry. I didn't understand. My bad.
All right. So you resolved this, Mr. ISF, with Mr. Jones?
Yes, Judge, we'd have.
All right, give me the facts.
It'll be a judgment by way of consent, possession only. The total is $277.89 to be paid on or before the 2nd of March, and I have his permission to sign his name to the order.
And Mr. Jones, you agree that's what you owe?
Yes, sir.
Thank you, Mr. Jones, for resolving this. We'll approve that consent judgment for possession only. You have to pay that $277.89 or move out by March 2nd. If you do neither, you could be evicted. You understand that, Mr. Jones?
Yes, I do, Judge.
Copy of the judgment will be mailed out to each of the parties after it's signed by the court. You each have a good day.
Thank you so much.
Next matter is Heritage Glen Apartments versus Monica Ford. Case 2603250. Ms. Ford, raise your right hand. You solemnly swear, affirm, tell the truth, whole truth, nothing but the truth, so help you God?
Yes.
Ms. Ford, you're here today for a first hearing on a non-payment of rent case. Did you read the advice of rights form that was mailed to you?
Yes.
Do you have any questions about your rights? Do you have any questions about your rights?
No. Can you hear?
She froze up a little bit, Judge.
Can you hear me okay, Ms. Ford?
Can you hear me?
Yes. Do you have any questions
Yes, I
about
can
your
hear
rights?
you. Can you hear me?
Yes, I can.
No.
Do you have any questions about your
Okay.
rights?
No.
Do you want to speak with a free legal aid attorney?
No.
All right, and Mr. Isop, have you resolved this with Ms. Ford?
Ms. Ford is paid in full, Judge. We move to dismiss.
Plaintiff's motion to dismiss is granted, and you each have a good day.
You too. Thank you.
This is Heritage Glen Apartments versus Wanda Jackson Bates, 2603270.
Mitch Joseph, plaintiff.
Good morning again, and you were Wanda Jackson Bates?
Yes.
Raise your right hand.
Yes.
Do you solemnly swear, affirm, tell the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Did you read the advice of rights form that was mailed to you, Ms. Jackson Bates?
Yes.
Do you have any questions about your rights?
No.
You want to speak with the free legal aid attorney?
Yes.
All right, we're going to put you in a breakout room with an attorney from Lakeshore Legal Aid. So don't leave till you.
Maybe put it right there.
This is the case of the state of Ohio versus Gerald Finley. Can you hear me okay, Mr. Finley?
Yes.
Case number 25 CR 43025. Present before the court is Mr. Finley, right? You're Mr. Finley, right?
Yes.
Represented by Mr. Wendell. We have Mr. View and Ms. Trainer from the prosecutor's office, Officer Henry from probation. We are here today for a pretrial, but it's my understanding Mr. Finley is going to enter a plea of guilty to one count of murder with the firearm specification, and that we're going to go forward with sentence today. Is that right?
That is correct, Your Honor.
All right. I also understand that there is a stipulation as part of the plea that Mr. Finley has been informed that he has the right to have a hearing on the issue of the notice of requirement to enroll as a violent offender, but he is going to waive that, agree that he's the principal offender, and that applies to him. Is that right?
That is also correct.
All right. Mr. Finley, how old are you?
I think 78.
How far did you go in school?
I had 2 years of junior college.
Are you able to read and write English?
Yes.
Are you under the influence of drugs or alcohol?
No.
Are you taking any medications?
Yes.
What medications are you taking?
Oh, I don't know.
Well, let me ask it this way, Mr. Finley. Are you taking anything that would interfere with your ability to understand what we're doing here today?
I don't think so.
Are you a United States citizen?
Yes.
We've had some discussions about your case. If you enter a plea of guilty to this charge, the notion is to go forward with sentencing today, that you would be sentenced to a period of incarceration of 15 years to life, plus 3 years for the specification. So it would essentially be an 18 to life sentence. Other than that, has anybody made any threats, promises, or representations to get you to plead guilty to this charge against your will?
No.
I have a document here entitled Change of Plea and Entry, and it looks like on the second page is a signature above the line defendant. Is that your signature? Tell you what, Ms. Grocka, why don't you go show that to him?
What is it?
This is the plea form that we reviewed together, and he's asking if that is your signature.
Yes.
Did you review the document with Mr. Wendell before you signed it?
I did, didn't I?
That was yesterday.
I'm having a real hard time with my memory.
Okay.
Yeah, but yes, I guess.
All right. You and Mr. Wendell reviewed this form together.
Yes.
Are you satisfied with the representation that you have received from your lawyer in this case?
Yes.
You're going to enter a plea of guilty to 1 count of murder. This is an unclassified felony. It's punishable by up to 15 years to life. You're also going to plead guilty to a firearm specification. That is a 3-year firearm specification, which will be served consecutively to the 15 years. We also have the issue of your duty to register and to enroll as a violent offender. There's a complicated statutory procedure for that, but the simple part is you have the right to file a motion to contest that. But as part of this plea agreement, you're not going to contest that. You do acknowledge that you're the principal offender and that you're going to register as a violent offender in the event that you ever get out of prison. Do you understand that part of it?
Yes.
All right. Before we go any further, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. If they can, they have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial. You can compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to this charge and the specification, you're going to waive all of those rights. You're going to admit that you did it, and we're going to get on to the matter of the sentence. Is that what you want to do?
Yes.
We also had what we called a motion to suppress in this case. I issued a decision indicating that some of the statements would be admissible against you that you made, and some of them would not be admissible. You also have the right to appeal that finding, but if you enter a plea of guilty to this charge, you are agreeing that you are not going to contest the rulings that I had on your confession. Do you understand that as well?
Yes.
All right. Mr. View, Ms. Trainer, what are the facts?
Your Honor, if the case were to proceed to trial.
Mr. View, I apologize for interrupting. Before we've had the opportunity to confer with the victim in the case.
Yes, Your Honor.
Victim representative.
Ms. Kennard's been in contact with the victim's representative, notified her of our intent to proceed with the plea today, what the plea was and the outcome that we expect.
Okay, go ahead with the facts. I'm sorry for the interruption.
Your Honor, if the case were to proceed to trial, the state would produce evidence beyond a reasonable doubt that on September the 7th of 2025 in Deerfield Township, Warren County, state of Ohio, that the defendant did purposefully cause the death of Amelia Vinegar and that the defendant had on his person and used a firearm in order to facilitate the offense.
Anything on those facts, Mr. Wendell?
No, sir. Thank you.
Mr. Finley, did you hear the facts that Mr. View just read into the record?
Yes.
Do you admit that those facts are true?
Yes.
Do you understand the rights that you're giving up by entering a plea of guilty?
Yes.
Is this what you want to do, Mr. Finley?
Yes.
What's your plea?
Guilty.
Based upon the plea of guilty, I'm going to find you guilty. I think that you have made a knowing, voluntary, and intelligent choice here today, only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. It's my understanding that the victim is amenable to going forward with sentence today, and that is the preference of all the parties, right?
Yes, Your Honor.
That is correct.
Any reason not to go forward with sentence today?
No, sir.
All right. Mr. View, Ms. Trainer, on behalf of the state.
Your Honor, we would ask that the court enter a sentence of 15 years to life as to the murder count 2, and with an additional consecutive term of 3 years, mandatory as to the specification to count 2. Additionally, the defendant be found to be the principal offender and be ordered to report according to the violent offender database. I know under the statute, in terms of questions of fines and costs, certainly we would stipulate that he is indigent and it would be unable to do that. We have no objection to the court waiving those costs.
Ms. Wendell?
Your Honor, thank you. Certainly the sentence is by statute. We appreciate the state's stipulation relative to indigency. This is what Mr. Finley would like to do. And that's why he's tendered this guilty plea and accepts his responsibility in the matter. Your Honor, thank you.
Mr. Finley, what do you want to tell me, if anything?
Nothing. No,
All right, the court is going to impose a sentence of 15 years to life. I am also going to impose an additional 3 years on the gun specification. This will be served consecutively to the 15 to life term. This is an indefinite sentence, but the 18 years that is on the front end of this is all mandatory time. I do find that you're indigent for the purposes of fines and costs. There will be no financial sanction. I also find that you are to register in the violent offender database. That means that you are the principal offender and that you meet the statutory requirements in that regard. Is there anything else we need to do or anything that I forgot?
Your Honor, only I sent the draft sentencing entry and I neglected to put it's 3 years on under the imposition of the sentence where it says as to the specification to count 2. I left the 3 out there. So if the court wants to just.
I can just fix it right here. I have it on my screen.
Other than that,
it just says a year mandatory. You want that to be a 3-year mandatory prison term to be served consecutively, right?
Correct.
All right.
And I'm assuming the sentencing entry dismisses the balance of the counts of the indictment.
Yes, it's actually the plea entry that dismisses counts 1, 3, 4, 5, and the specifications to those counts.
Thank you, sir.
All right. Mr. Finley, you do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer, to obtain a transcript, or to pay the costs, they will all be provided to you without charge. Good luck to you, Mr. Finley.
thank you.
Thank you, Judge.
Okay.
Thank you, Ms. Trainer.
You're welcome.
It's a pleasure working with you.
All right. Also before the court is Mr. Stephen Saladay, an agent from the Michigan Department of Corrections, serving as the probation officer here today. We are here today for an arraignment on a requested warrant for a probation violation. Like there had been a previous show cause. Hold on. There was a request and summons for a probation violation that was filed on January 21st. The court ordered the defendant to appear on February 5th. And failure to appear, a requested warrant was filed. However, before we Oh, he did appear. I'm sorry. And then I released him on a PR and then failed to appear on February 9th. Thank you very much. All right. So, Mr. Manicki, we're here today for this probation violation hearing. I still think I need to advise you. Is there a amended charge, Mr. Saladay? No? Okay. Requesting more with the same charges. Yes. All right, thank you. So, Mr. Manicki, we're still facing 4 counts for violating your allegedly violating the terms and conditions of your probation. Again, count 1 is that you were not in your approved residence between curfew hours of 10 p.m. and 6 a.m. on January 7th of 2026. Also, that for count 2 that you consumed alcohol on that same date. For count 3, you failed to appear for your show's cause hearing on, so we did have a count, on February 9th of 2025. Okay. So that's a new added count. And then also you had count 4 that you actually committed disorderly conduct on or about January 7th of 2026. Mr. Harrison, what are we doing today?
I would like the opportunity for an informal. If that's not available, I believe I had some preliminary discussions with Mr. Saladay, but in the interim, I was unable to locate Mr. Manicki and they never proceeded beyond that.
Okay. Right.
I can do that.
Well, let's see how many final pretrial conferences are yours this morning?
3.
3? All right.
Then there's the motion in the AG's case.
All right.
And I believe 2 pleas, but.
Okay. All right. Well, first of all, Mr. Manicki, again, I've gone over those 4 counts. I need to tell you once again that, as I told you before, you have the right to challenge not just the first 3, but also now all 4 alleged violations of violating your probation. You have the right to have the prosecutor prove the allegations by a preponderance of the evidence, the right to be represented by counsel at the hearing, as well as any subsequent proceeding. Also, the right to question and cross-examine any witnesses against you, and the right to present witness evidence for testimony, and also the right to remain silent and not have that silence used against you. If you're found to be in violation of your terms and conditions of probation, you would be resentenced on your original offense. Was this resolved with a UDAA or the unlawful use version?
Unlawful use, Your Honor.
All right, so that's the misdemeanor,
Yes.
and that's punishable by. Oh, there we go. It didn't get tagged. It's actually a high court misdemeanor punishable by up to 2 years, $1,500 plus suspension of the defendant's driver's license. And based upon the fact that there's at least 1 non-technical, the court is not limited to a sliding scale. All right, thank you. The court will adjourn the day, have it set for an informal hearing. Now, to do that, since today it starts 14 days, again, because I had to re-advise them of the count 3.
I will happily make a preemptive waiver of the 14 days due primarily to my unavailability in the first part of next week.
No problem, I understand.
I don't want to lop over a date just because I'm in a trial.
I'm in a trial too. So.
Yeah.
All right. The court will continue the not guilty plea. The court will continue to have it set for an informal hearing. Anything else to hear from Mr. Carnes?
Your Honor, I would just ask that the court remand the defendant pending the hearing given the.
Oh, that goes without saying. All right, Mr. Harris, unless you want to, you get the right to make an argument. Maybe there's something I don't know out there. Maybe he was working special forces someplace I don't know.
No, at this juncture, I believe that a remand actually makes sense.
All right, thank you. The court's going to deny the defendant's bond and remand him into the custody of the Washington County Jail pending that informal hearing, which will be within maybe the next week, if not within the next 2 weeks. Thank you.
Thank you, Your Honor.
We are adjourned. Go ahead and give me the file. Oh, no, you can give me Mr. Towers. Can you get hers out of there? Or wait, we got both her and Castle.
Yes.
Wow. Like tag team.
Mr. Harrison is here.
Oh.
Okay. Their code.
Oh, yeah. That's right. Well, hold on. I don't have Mr. Dodge either. Just somebody get me a couple defense lawyers and prosecutor.
Well, we know you like, in person, so we thought we'd
I love in person.
so that, we can get some points and you'll grant our motion and it was.
Wow. Oh, now I see how it's done.
You said it, I didn't.
I didn't.
So,
All right, thank you. Thank
I
you.
don't remember. Courage. Yeah, he's still on there.
All right. So am I taking these both at the same time? Because they're
They're
co-defendants?
co-defendants, yeah.
Copy that. All right, so Nancy, get ready,
Yes, I am.
hit play or record. Thank you. All right, folks, we're going to take up two cases here at the same time as their co-defendants. The first file is People of the State of Michigan versus Christopher Allen. File number is 25-14161F. And in that file, appearances, please.
Good morning, Your Honor. Abigail McIntyre appearing on behalf of the people, P71143. Good morning, Your Honor. Lisa Kirstatawa appearing on behalf of Mr. Allen, who is present.
Thank you. Sir, you may be seated. Now, looking to the next file. People of the State of Michigan versus Wesley and Connor. This is file number 25-14162FH.
Good morning again, Your Honor. Abigail McIntyre appearing on behalf of the people.
All right. Who is the defense?
I'm Jeff Harrison. I'm here on behalf of Ms. Connor. As the court will note, she is not physically present. She is present by Zoom. I had a conversation with her this morning. She was in the hospital last night with some kind of sepsis-related infection.
I got it. I don't need to know. What? Thank
There's
you.
no objection for the people that she.
All right.
Thank you.
Thank you. All right, so we're here today. That for a final pretrial conference? It is. And I know we have a trial date set in about a couple weeks. We have a motion here. Let's go ahead and take care of the motion. The motion is to adjourn the trial in the Christopher Allen file.
It's for the both.
And Wesley Connor. Do we have them joined together for one trial? Do we?
We do, Your Honor. I don't know if Ms. Satawa is going to be filing a motion to sever.
Okay.
But that hasn't been filed yet, to my knowledge.
All right. So
I actually have a draft with me, but so it'll be.
we can make it early, so we'll talk about that, or but we'll see if we need to raise that up first. Then I also saw that there was an intent for 76827B information, and that was filed in the Wesley and Connor file.
That's correct.
Does that apply to both?
No, just applies to Ms. Connor.
Thank you. All right, so let's deal with the people's motion to adjourn the trial date.
Well, Your Honor.
5 CR 42659. Present before the court is Ms. Williams, right?
Yes, sir. Yes, Your Honor.
She's represented by Mr. Wendell, and we have Mr. View from the prosecutor's office. The docket says hearing on the issue of competency, but that is not why we are here. We are here on the issue of placement and pretrial. So here's where we're at. The court has assigned my mental health officer, Officer Martinez, to look into this. When I released Ms. Williams to the community, it did not last very long. And we're trying to sort of figure out a way, Ms. Williams, to get you someplace that is not the jail. So I don't have that place yet, but if I get that place, I'm going to go ahead and move you there. So let's say, for example, that a bed opens up in an appropriate facility, someplace that you can go. I'm just going to do an entry and send you there. If the victim wants to object to that, they had the opportunity to object to it today. Mr. View, you can certainly advise the victim, alleged victim for Marcy's law purposes, that if he wants to be heard on that issue, he can let us know. But if we have a bed somewhere or something that we can do, I'm going to go ahead and act on that immediately. We're going to set the case for another pretrial in 30 days, right?
Yes.
All right. Anything else from the state?
No, Your Honor.
Anything else from the defense?
Yes.
Okay. What, Ms. Williams?
I have a health condition, which is at Summit, they found bone dysplasia. Okay. When I had a DEXA scan done, I broke my wrist at Summit in 3 places.
Okay.
And I had a cast. They did a DEXA scan, and they found bone dysplasia. And dysplasia is precancerous cells. I had breast cancer and lymph node cancer. So the progression is next is bone, liver, or brain. So it appears it's in my bone.
Have you talked to the folks at the medical center over at the jail yet?
Yes, I have, about
Okay.
10 times. I've had,
All right,
I
so-
sent something to you as well yesterday.
Okay, so what I'm going to do, Ms. Williams, is I'm going to have my assignment commissioner, Ms. Idle, she's going to reach out to the folks in the jail, and she will get their take on all of this,
It's all on the kiosk.
Okay.
Medical kiosk.
and then we'll see what we need to do next.
Okay.
Okay, all right,
Methadone treatment is what I hear is what it is.
okay, all right, that's all.
Thank you, Judge. Okay, so I have an investigator today.
Oh, okay.
So I'm gonna try to see if we can do that. Is there a way that I could meet with Ms. Wood?
Session, the Honorable Judge J. Cedric presiding.
Good morning, everyone. Court does call the case of Clark Road Family Limited versus Shayla Cole.
Good morning, Your Honor. Amanda Sprague, P81931, appearing on behalf of the plaintiff.
Do we?
I'm all here.
Ms. Cole?
Yes,
All right, I'll need a camera.
my camera in the front broke.
Okay, whatever. What is plaintiff's claim?
Yes, Your Honor, we're here today regarding a non-payment of rent case. I do show that there is currently due and owing to the plaintiff past rent in the amount of $4,375, as well as court costs in the amount of $239. Your Honor, my Excel spreadsheet just crashed, so if you give me just a moment, I can tell you what that balance will be.
Okay.
It would be a total due of $4,614.
Ma'am, how are you intending on getting this taken care of?
I'll be able to pay all of it by Thursday.
By Thursday, you're gonna pay everything by this Thursday upcoming?
Yes,
Okay. So I'll indicate you're gonna pay the balance by the 26th.
yes,
I'll adjourn this then to February 27th, 2026 at 1 p.m. If you have everything paid, you don't need to come down to the courthouse. Otherwise, that is an in-person court hearing. All right?
okay.
Okay. Thank you.
Thank you, Your Honor.
Thank you. Is that it for you?
I'll be back at noon.
Okay. All right. Very good.
Thank you.
Barnes and Barnes versus Chelsea, is it Parkyla?
Ellis Friedman for the plaintiff.
And Daniel Green. Parkyla Green.
I could see Parkilla's here.
Where?
Hello.
Oh, there you are. Okay. I was actually looking for a person and not like a cereal bowl or whatever that was. Hello. All right. What is the claim, Mr. Friedman?
The total, Your Honor, including costs, is 2828.95.
Ma'am, how are you intending on getting this paid?
I've made an agreement with Barnes and Barnes that I can pay in 2 installments towards the end of the month because of how our paychecks fall. So around the 28th, I'll be able to pay half of it, and then hopefully before the end of next month. But I have made an agreement with Jessica about it.
Mr. Friedman, you know anything about that or?
No, but
Okay.
I don't, Your Honor. So I guess if we adjourn it a week, which we would normally do anyway, we'll get to the bottom.
So
of it.
ma'am, what I'm going to do is I'm going to adjourn this out a week. And hopefully that can be memorialized into maybe a conditional order dismissal or something along those lines, okay?
A traditional order of dismissal, can you explain what that is?
A conditional order dismissal, meaning that typically, well, the basic framework of that would be that the case would be dismissed and remain dismissed as long as you would fulfill the terms of, say, a payment agreement. All right.
Great.
If you
Thank you so much.
don't, then what would happen is that if you who is that? If you fail on that, then what would happen is the plaintiff would get their judgment as well as an immediate order of eviction.
Okay, great. Thank you.
Okay, but that would have to all be worked out in terms of what those terms would be. Mr. Friedman, while you may have talked to your landlord, he doesn't know anything about that, so we'll have to figure that out. So I'm going to adjourn this to February 27th, 2026 at 2 p.m. That's an in-person hearing. And likely, ma'am, you'll have to be here on that date so that we could enter, if it's a conditional order dismissal or a judgment or whatever, we can enter it. Okay?
Okay, thank you.
Thank you.
Thank you, Your Honor.
Thank you, sir. Barnes and Barnes versus Alana King.
Ellis Friedman for the plaintiff. I did see her on the panel.
Oh, there she is.
Hello.
Hello, Ms. King.
Hi, good morning.
She can hear us. Can you hear us, Ms. King?
Yeah.
Okay, I'm having problems hearing you. I don't know if your microphone's covered or something. But I think that might have gotten better. Okay, can you say your name?
Elena King.
All right, we can hear you fine now. Okay, I don't know what it was, but we can hear you. All right, Mr. Friedman, what is the plaintiff's claim?
2865.00.
2865.00. All right, ma'am, how are you going to get that paid?
I would need a new, I guess, ledger with the full balance, but I have been in contact with Hawk, as well as DHS. I filed an application for a state of emergency relief.
Yes, ma'am.
This is coming after just a termination and like a string of bad luck. So I'm not as familiar with the eviction process. And so I was told to contact legal services of South Central Michigan as well. And I do have an appointment with SOS that Hawk referred me to.
Okay, that's fine.
Scheduled for March 7th. So it sounds like I'm eligible for assistance. It's going to take a bit of time. I know that it's getting into March here. And my concern was that it's January and February owed now. But I do hope to get assistance between that Hawk agency as well as the provisions program.
Okay. All right.
Yeah, through DHS.
Gotcha. Okay. So first thing, there's a form that came in your packet that's called a rental assistance form. You'll need to fill that out and file that with the court by next Wednesday.
Okay.
Okay. You said your Hawk appointment is March 7th.
Yeah, March 7th at 11 a.m.
Did they know that you were going to be in court now? Or did you
Yes.
tell them?
Yes.
Okay.
That was the soonest available appointment they had, and they said to make sure to let the court know.
Yeah, the problem's going to be, how much is your monthly rent?
$11.95.
Pardon?
$11.95.
So about $1,200.
Yeah.
Okay. So here's what's going to happen, and why I asked that is because if Hawk were going to give you the full amount of assistance, it's only going to be $3,000. Okay, and you're about at that figure right now, and you're going to be at come March, if nothing's paid, you'll be at 4,000. Right.
And so I spoke with, I believe his name was Terrence. And that was a caseworker at DHS. That was, I was referred to like the provisions program. And they said that they would cover up to 4,000, or whatever is the remaining balance that's not picked up by Hawk. In addition to like, you know, as an additional agency that can provide assistance on, past due rent. I did say that, you know, getting into March, that was my concern. So that so far is the plan. They told me to reach out to legal services to, and once I made contact with someone there, that they could get the ball rolling on the application for their assistance as well. They are, they mentioned that as well as like some DTE. I'm sorry, what was that?
Which assistance was that somebody said up to 4,000? That's not on rental assistance, is it?
It was through, I've been pretty down on my luck and had some really upset, I'm a survivor of domestic violence. And so the fathers of my kids have been kind of terrorizing me a little bit. And I'm not sure if that's the reason for losing my job and everything else. I'm sorry.
Okay, it's all right. All right, let's do this.
CPS. They called CPS as well. And so after I spoke with the CPS supervisor, they referred me to what's called the provisions program through the Department of Health and Human Services. And they said that they would provide additional assistance for whatever Hawk didn't cover. And it would be up to $4,000.
Gotcha. Okay. Ms. King, do me a favor. Take a deep breath. Okay. You got there's a lot going on with you and what you're worried about. Right now, don't worry so much about this. We'll walk you through this process. Okay. All right. Fair enough. Okay. So I just need that form. You need to get that form down to the court by Wednesday with just that information, okay? Because that's going to get you some additional time in any event, okay? Then what I'm going to do is I'm going to adjourn this out to February 27th, that next Friday, 2026 at 2 p.m. That's an in-person hearing. If you have a reason why you might need to appear via Zoom, you can fill that form out and get that to the court and we'll deal with it. Okay. The other thing that I'm going to do is I'm going to put you into a breakout room with our court liaison officer and see if there are other resources out there that may be available to you to kind of get this, see if we can get you over the hump on this. Okay.
Thank you.
All right. Amy, she there?
Yes, Your Honor.
All right. I was going to put you into a breakout room with Miss King so you can talk with her and try to work through it and see if there's other things she can work through. Okay, Miss King, do me a favor. Okay. I know you're worried. The eviction process can be kind of strange. You don't need to worry about anything right now. Okay, we'll get you through this. All right. All right. You take care.
Thank you, Your Honor.
Yes, thank you, Mr. Freeman.
I'll see you later this afternoon.
Yes, sir. Can you, okay, we got it. Peninsula Place versus Unique Homes.
Good morning, Your Honor. Rebecca Austin.
Unique Homes. Do we have her? Hello?
No, she is not.
All right, she's not here. Counsel, if you'd like to take a default, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
Do, Your Honor.
All right, go ahead.
Your Honor, non-payment of rent, the outstanding rent, in the amount of $4,916.99. Court cost of $177.70 for a total of $5,094.71. Upon information and belief, Ms. Holmes is over the age of 18, not in military service, and is not incompetent. This property was kept fit for its intended purpose and in reasonable repair.
Judgment to the plaintiff, that's by default for possession. Redemption amount in the amount requested with the writ issue in 10 days. Court does call the case of the Peninsula Place versus Camille Cox.
Good morning, Your Honor. Rebecca Austin for plaintiff.
Ms. Cox? Camille Cox? Oh, almost. I need you to unmute and turn on your camera, please.
Okay, I'm here.
Okay, I'll need a camera. What is the claim in this case?
That's a non-payment of rent case. There's currently past due rent with cost the amount of $993.93.
$993.93.
Yes.
So, okay. I didn't know if I was double hearing or what was going on. All right. All right. Ms. Cox, how are you intending on getting that paid?
I'm going to pay the full amount next Friday.
On the 27th?
Yes.
All right. Well, you're entitled to an adjournment. I'll indicate that you're going to pay the balance by the 27th. Their time on the 27th is what?
Yeah.
Can you get that paid early in the morning or say on Thursday?
I can pay early on Thursday.
So the reason I'm saying is because I'll adjourn this out to the 27th, 2026 at, you said 1?
Yes.
At 1 p.m.
Okay.
If it's paid before then they'll know, and then the matter can likely be dismissed.
Okay. I am
right.
going to have to get, am I able to pay online?
No, Your Honor, when they're in the court process, they're locked out of the online portal, so she'll have to pay with a money order or cashier's check.
And that makes absolutely no sense to me. I don't know why companies do that. It's just crazy to me. I don't know why you just won't take the money. All right, ma'am, you can do it one of two ways. They won't take your money, the court will, and we'll hold it, and then they'll have to wait for their check. But I guess it's not open, so however you can do it, try to get it paid.
Okay.
All right. And you'll need to come down to, if it's not paid in full, you'll need to come down to the courthouse on that day.
Okay.
All right.
Yes.
Okay. All right. Thank you, ma'am.
No problem.
Peninsula Place versus Taya Malcolm.
Rebecca Austin for plaintiff, Your Honor.
She's here. Malcolm?
Hello.
Hello. How are you?
Good. How are you?
I'm okay. All right. What is the claim in this case?
Your Honor, there's past due rent with the amount of $2,473.21.
All right. Ms. Malcolm, what's your plan for getting this taken care
of? I paid $820.49 yesterday. However, I do have an issue. I made a payment on January 6th at 2:00 to the residence portal before it shut down. And that was a payment of $1,000 and $1,088. However, they are saying that they didn't receive it. I did email them the receipt with Blitz, telling them that the payment did process through and everything. Shannon, I believe, is the assistant manager I've been emailing. She's seen that the payment was taken out of my account and everything, and suggested that I contacted either my bank and the rentals portal to see if they can revise to get the money back. When I went to go get my cashier's check yesterday, I did tell the bank the situation. However, they can't do anything about it. So I have to contact now the renters portal, and I'm waiting to receive the email back for them. So technically my remaining balance should be like $479 since me making the payment yesterday. And those are random charges. I have no idea. I also been emailing them since October about these charges, and I have yet to receive anything, a ledger dealing with what these extra charges are. I have no problem paying it. I just want to know what I'm paying for.
You done? No, no,
Yeah.
it's okay. That was a lot. So no, I followed it. I just didn't know when it was going to end. Okay.
Oh,
so
sorry.
Counsel, do you know anything about that January payment? I mean,
I do not, Your Honor. I will tell you that my company bought this property around that time. So perhaps with the agreement, I can dig into that as well. And my property manager's online as well, Holly. So we will dig into what happened with that $1,088 payment on the 6th. That might have been right.
So and as I'm understanding what's happened, so it came out of her account. The only people that it would have paid would have been either your company or your predecessor, but she would have paid her rent.
I appreciate that. Right. So if it's paid,
Right.
we'll figure it out and give her the proper credit for it. So we can do that in next week's time.
Okay. And then she paid 800 and it was some interesting figure, but anyway.
$820.49.
Eight what?
$800, $820.49.
Okay, that's what she paid yesterday. No.
Yeah.
Okay, you can hold that up. I can't see it.
Oh, sorry.
My eyes aren't
Yeah,
that
I
good.
was
I believe you. Do you have that on her account?
Holly, did we get that payment yesterday?
Yes, we did.
Yes, Your Honor.
So that came off of this figure
It's
that
not.
you gave me?
That 2,400 I just gave you did not include that 820, so it's reduced by that amount. I did not have that until I was unadvised before the hearing.
Okay, so I need to know if you have that 820, what is her?
It would be
give me 2473, 21 minus 820. 820, and how much? What was the change on that?
49 cents.
Young lady?
40 cents?
You said 40?
49 cents.
49.
1652.72.
That's what
1652.72 is actually what her balance is.
Right, and then obviously reduced by another 1,088 once we get that proof.
Right, and then she's just still going to be around 600. You're thinking 400, but that's probably because without the court.
Well,
costs.
yeah, it will be
Okay.
564.72. I just wanted to know what those remaining charges include. I have no problem paying it. I've been emailing them since October.
You're killing me. I know. I heard you. All right. I'm just trying to get. I'm trying to get it to a
My
number.
information straight.
Okay, no, we'll get there. I just have to have the number right. Okay, so now that I have the number right, we've got to get your credit, and then we can figure out what all that stuff came from. All right, fair enough. So what I'm going to do, ma'am, is I'm going to adjourn you out to February 27, 2026 at what time? 1 p.m. That's an in-person proceeding, so you'll need to come down to the courthouse. And counsel, ma'am, do you have a copy of a ledger or no?
Yes, they emailed it to me about 2 days ago.
All right. So counsel, if you guys aren't here in person, but can you make sure the court gets a copy of the ledger?
Absolutely.
So that we can try to get everything straightened out. Okay? So that this young lady doesn't have to do any more math, because I don't know why you pay 49 cents, but I'm not into that. All right. Okay. Ma'am, we will see you next week.
All right. Thank you.
Take care. Peninsula Place versus Demarius Watkins.
Rebecca Austin for plaintiff, Your Honor.
Demarius Watkins.
Mr. Watkins? Okay, there you are, sir. All right. And how much is claim going on this?
$2,976.65, and that includes the court costs, Your Honor.
All right. And Mr. Watkins, how are you going to get that paid? you think, sir?
I put in the SCR and
Okay.
I got in contact with the Hawk program. I have a meeting on the 23rd of this month.
Okay. So you got a Hawk meeting on February 23rd, this Monday, I think it is. All right. And you put in SCR. Okay, so there's in your packet, there's a form called the rental assistance form. You'll need to fill that out with your tracking number from your SCR. You won't have a tracking number for Hawk, but your tracking number for your SCR, make sure that's on there, make sure it's filled out. You need to file that with the court by Wednesday.
Okay.
Okay. And then I'll adjourn your case out to February 27, 2026 at 1 p.m.
Yes.
At 1 p.m. That's an in-person proceeding, so you'll have to come down to the courthouse. Okay, sir?
Yes, sir. You said February, which date? I'm sorry.
27th, next Friday.
Okay, thank you.
At 1 o'clock. All right. Okay, take care. Peninsula Place versus Zaria Fisher.
Rebecca Austin for plaintiff, Your Honor.
I'm here.
Oh, where? Okay, she's the phone 766. All right. When you say you're here, your name is Zaria Fisher?
Yes.
Okay. All right. What is plaintiff's claim?
Your Honor, the total claim is $2,666.12, inclusive of costs.
All right. Ms. Fisher, how are you intending on getting that paid?
I can pay $1,300 by Monday.
So you can pay $1,300 by Monday.
Mm-hmm.
All right. And then how would you plan on clearing up the rest of this?
And I'm just working, so I should get another check the following week.
Okay. All right. So here's what I'll do. Get the 13 paid, and then I'll adjourn your case out to the 27th, February 27th, 2026 at 1 p.m. That's an in-person proceeding. And so you'll have to come down to the courthouse and we need to figure out how we're going to get this taken care of. Okay.
Okay, sounds good. What time was that again? I'm sorry.
That's at 1 o'clock.
1 o'clock. Okay. Thank you so much.
All right. Thank you. Peninsula Place versus John Robinson.
Rebecca Austin for plaintiff, Your Honor.
Not present. Robinson, they're not present. You may proceed, counsel.
Honor, request of possession only, default judgment, rents retained $1,652.82. Court cost of $177.72 for a judgment of $1,830.54. Upon information and belief, Mr. Robinson is over the age of 18, not in military service, not incompetent, and this property was kept fit for its intended purpose.
But to the plaintiff, that's by default for possession, redemption amount, in the amount requested, writ to issue in 10 days. Peninsula Place versus Jonathan Jones.
Rebecca Austin for plaintiff, Your Honor.
Jonathan Jones, not present. You may proceed.
Your request of possession only, default judgment, rents retained $1,721.53. Court cost of $177.72 for a judgment of $1,899.25. Upon information and belief, Mr. Jones is over the age of 18, not in military service, not incompetent, and this property was kept for the in reasonable repair.
Judgment to the plaintiff by default for possession, redemption amount, in the amount requested, writ to issue in 10 days.
Thank you.
Peninsula Place versus Nafi, is it Tiwa?
Rebecca Austin for plaintiff, Your Honor.
They are not present. You may proceed.
Your Honor, I'd request a possession only, default judgment, rents retained $2,246.21. Court cost of $177.72 for a judgment of $2,423.93. Upon information and belief, the defendant is over the age of 18, not in military service. It's otherwise within the jurisdiction of this court. This property was kept fit for its intended purpose.
Judgment to the plaintiff by default for possession, redemption amount, in the amount requested with a writ issue in 10 days. Peninsula Place versus Faith Osai.
Say Your Honor, here.
Okay, hello.
Hi.
All right, what is the claim?
Grant of past report costs of $2,811.50.
Ma'am, how were you intending on getting that paid?
So I had been waiting on some student reimbursements, and then I just received them last week. So I have the intent of putting that down. But then I also realized my March rent is going to come in. I only get paid twice a month because I work in education, and I had to pay a larger installment for the day I moved in. So I wasn't able to make up that payment because I was in the middle of transitioning jobs. I'm unsure if I will qualify for emergency relief because I'm technically not a permanent resident of Michigan. I'm only out here for school. So I'm not sure if they'll even make me eligible for that. But I have been, for most of the 5 years that I've been here, almost 5 years, I've been mostly in the state of Michigan. So I'm just not sure if they'll accept that application.
Okay, you're a student?
That's correct, yes. I started at Wayne State in fall of 2021. I just transferred to Western Michigan after financial constraint again at Wayne State. So I'm online attending classes at Western.
Why don't you just stay at Wayne State?
I tried to.
I'm just asking that. I'm a bit biased. That's where my son goes. So my dad graduated.
I 100% liked what I did at Wayne. I was a finance student. However, a lot of different financial situations through their financial aid office made it very difficult for me to stay. I ended up having
Gotcha.
Really.
I gotcha. So what are you going to be when you grow up?
At Western, I switched majors. I'm now working in youth and community development. I am currently a paraprofessional at a high school within Washtenaw ISD, and I'm planning to become a family policy advocate. God willing.
No, that's a lot. I wouldn't have been able to do all that. Yeah. All right. Okay. So, have you tried to contact Hawk at all?
I'm unfamiliar with Hawk. I got served when I was at work, so my roommate had to put the papers underneath my.
Okay, no, that's fine.
Let's
do it this way. Here's what I'm going to do. I'm going to adjourn your case, first of all, to the 27th, 2026 at 1 p.m. That's an in-person proceeding.
Okay.
Regarding you're just a resident of another state, but you're really here, correct?
Correct. Yeah. So my permanent residency is of Minnesota.
Minnesota, really?
Yeah, born and raised.
Why Minnesota? All right, no, I'm not going to get on your back. I'm just going to say, if I had a choice, Minnesota or Michigan, I'm going to the Mitten. I don't know why you're there. Anyway, that's your business. Okay, so let me do this, and let's see if there's some funding that you're eligible for. Okay. But I'll do that in a moment. You said you have some monies that you can put down?
Yeah, so I can put down $850 today. I get paid.
Okay.
It might be a shorter check, but I can put down a decent amount of that, maybe like $500. My bank account has been.
Hold on a second. You can give $850 today.
Yes.
Okay, and then what were you saying?
I was saying I get paid again. It should be next Wednesday at the latest. I can put up to like $600 down on that.
Okay. So next Wednesday, you're talking about the 25th.
Correct. Let me make sure. Give me 1 second.
That's this upcoming Wednesday.
Yep, that'll be correct. Because our payment periods are at the end of each month in the 15th.
All right. So that's that. And let's see. And then you're going to be trying to work the rest of that out.
Correct.
Right.
There was a large sum of money that was taken out of my account. So I'm working through my bank with that. that was gonna add on to the additional $850 that I need to put on, but they're still working through the dispute charges. so-
Okay, all right, okay. So let's do that. I'm gonna, have you not called Hawk?
I have.
Because, okay, why don't you give them a call?
Okay.
You might be right on that residency thing, but there also might be certain things out there that might help you because you fall into other categories, okay?
Am I?
All right, do you have their number?
Yes, I have it on this sheet right here. Quick question about the state relief. I'm just gonna try to do the application, whatever they determine is on them. But as far as like the
house arrest, Mr. Isaacs has been compliant with all terms of pretrial supervision so far. He's been testing clean. He has had no violations of his house arrest. He's having a surgery on Tuesday, which Community Corrections has agreed to remove the monitor for the surgery. We are asking the court to keep the monitor off and just allow him to be on pretrial supervision. If the court is not inclined to grant that request, we request the monitor be moved to a curfew instead of the house arrest.
Mr. Goodyear?
We have contacted the victim regarding this matter, and I can tell you that they are very, very strongly opposed to the idea of any amendments or any changes to his current bond. Judge, I know we've had discussions about the case, and I'm sure you're aware of what his prior criminal history is, but Mr. Isaac has a long criminal history here in Warren County. These allegations are very serious. He's facing a substantial amount of time in prison if convicted. And just the allegations of supplying drugs of this nature to a minor are obviously very concerning. So the state thinks that the current conditions are adequate and reasonable under the circumstances. We ask you to maintain them.
What I'm inclined to do, first of all, we are going to do the removal for the surgery. You already got that worked out with the folks at Community Corrections. I'm not going to remove you from the monitor today, Mr. Isaacs, but I am going to move you to a curfew, 8 o'clock a.m. to 8 o'clock p.m. You're in, 8 o'clock a.m. You're back out. During the day, you can do what you need to do, and that's as far as I'm willing to go. Anything else for today?
No, Your Honor. Thank you.
All right.
Thank you.
We already have a trial date and a conference, right?
Yes, Your Honor.
Yes, sir.
Okay.
housing address, do I just put the address for Peninsular Place or my residency of Minnesota's address?
Whatever they ask for, but I'd probably, you're really domiciled here. I mean, you have a permanent resident in Minnesota, but I know that they have helped students out before, not from as far away as Minnesota, but from Ohio. But that's only because we get more of those than, I guess. What are you guys, like Gophers or something? I don't know.
Yes,
Anyway.
Yuma.
Okay. Yeah, it's something like that. Whatever. Never figured that one out either. But here's what we'll do. We'll do the 27th at 1.
Okay.
Call down to Hawk.
Okay.
See if you can get an appointment with them. You can fill out the SCR.
25 CR 42780. Present before the court is Ms. Moses, right?
Yeah.
Represented by Mr. Ocello. We have Mr. Harris in the prosecutor's office, Officer Rose from probation. We are here today for a sentencing and for a final probation violation hearing. Hold on just 1 second. All right, everybody had the opportunity to look at the PSI?
Yes, Your Honor.
Any reason not to go forward with sentence today?
No, Your Honor.
We have 134 days of jail time credit, and we had, was it $80? What was the restitution on the monitor?
190.
I believe it was 190, Your Honor.
190, okay. Mr. Harris, anything from the state?
Yes, Your Honor. The court's familiar with the defendant. She has an extensive criminal history. Based on the nature of the case being this an escape, I think she's shown that she's not amenable to community control. We are recommending that she be sentenced to prison at this time.
Anything additional from probation?
No, Your Honor.
Mr. Cello?
Your Honor, thank you. On behalf of Ms. Moses, as the court is aware, we had raised the idea that back in May, when she was originally placed on probation, that she had had human trafficking underlying this incident where she had cut off her ankle monitor and left and absconded from the court probation. Unfortunately, we were not able to supplement the court with other than verbal information with any additional information to demonstrate that. Ms. Moses certainly is taking responsibility. I think having pled now, she's aware that the 2024 case with which there's some restitution that's owed, as well as this 2025 case is now before the court. She's asking the court to consider placing her on a period of community control with some inpatient treatment. As the court is aware from viewing the PSI and my conversations with Ms. Moses, there's a somewhat lengthy history of substance abuse, which masks some underlying mental health issues that Ms. Moses has. I think those stem from some physical and emotional and sexual abuse at the hands of a relative when she was at a young age. It seems as if just by looking at her history that throughout time she's used substances to mask issues related to that. We are asking the court to consider placing her on a period of community control with supervision and inpatient treatment to address these issues so Ms. Moses can learn better coping skills rather than addiction and use. So we'd ask the court to consider this information and crediting the jail time that she has earned against any sentence.
Ms. Moses, what do you want to tell me?
I made a lot of mistakes, and I made a big mistake with my ankle monitor, but I'm asking so I can get the help I need. I do need help, and I know I need to be punished for what I did do, and I'm truly sorry. And I returned back to jail on my furlough, and I'm trying to make things right. And I would really like one more chance to even some kind of treatment and some mental health help.
Ms. Moses, I don't think the return to the jail was particularly seamless because there's currently an investigation going on to determine whether or not you brought something back into the jail. I'm not asking you to comment on that because it's probably in your best interest not to, but we may have another case coming as a result of that. But what I do know, Ms. Moses, is I have this slice of people on my docket to whom those people believe that the rules don't really apply to them and that there's a rule, and that rule is probably good for general people like other people, but there's always this sort of way around it, or I should have an exception made for me. I think that you fall into that category, Ms. Moses, and for that slice of my probation docket, there's no way to supervise them. And to put you on probation, I think is a sort of a meaningless endeavor. But, my inclination on this case is just to sentence you to 18 months in prison. That's 9 months on each of these charges. And when you get out, you will be done with those. I will consider, though, Ms. Moses, and you may want to think about this and talk to your attorney about it. And if you don't want to make the decision today, we can come back. I would be willing to give you a shorter term of incarceration. So in other words, it would have to be, so I have to have a consecutive sentence. Here's the other thing that I could do. I can give you 18 months. The other thing I can do is I can give you 134 days in the 24 case and close that case out. So we'd only have one case, but I would impose 36 months in prison. That's the maximum penalty for that, and release you after 6 months in prison into a CBCF. That means that you would go to the Monday program, STAR program, someplace like that. So what you would be looking at would be 6 months in prison, followed by 4 to 6 months in a treatment facility, followed by probation. If you screw up your probation, I will send you back to prison and you will do 36 months. That's 3 years in prison. Or I can give you the 18-month sentence, 9 plus 9. Is that something that you want to think about? You want to talk to Mr. Ocello about it? Mr. Ocello knows all about this kind of stuff. He can advise you pretty easily. But this seems like a pretty big decision. Your Honor, I just confirmed with Ms. Moses. I asked actually 3 times to make sure that I had understood her correctly. She would, if the court is willing to consider, she would ask the court to credit the 134 days on the 2024 case, close that out, place her on probation on the 2025 case for a period of, I don't know what you said, I'm sorry. Whatever period. I'm not putting her on probation today. I'm sending her to prison today. She would be sent to prison for 6 months. She would then be eligible for a CBCF, and then after graduating from that would be eligible for probation. She would like to go that route. I understand that she's not on probation. I'm sorry, I misspoke. That's all right. Sure about this, Ms. Moses?
Yes.
Officer Rose, what do we think about this?
I think if Miss Moses hits the 6 months and she is genuinely serious about having help, the judicial could show that. But if she is not willing to do it, the CBCF will, if she gets unsuccessfully terminated from the CBCF, it will show she wasn't actually serious.
All right. There's nothing in the PSI to suggest we can't get her into a CBCF, right?
No, Your Honor.
Okay. Mr. Harris, state opposition on any of that?
No, Your Honor.
All right. That's what I'm going to do. I find that you have violated the terms of your supervision in the 24 case. I'm going to give you I'm going to sentence you to 134 days. I'm going to credit you the 134 days that you have already done. And I'm going to terminate that case. We'll just do a neutral termination on that case. In the new case, I'm going to sentence you to 36 months in prison. And I'm not going to impose a fine. I am going to impose the cost. This also carries with it an optional period of post-release control. That means if you do your whole sentence, the adult parole authority can, but is not required to supervise you for up to 2 years after your release. If you violate the terms of that supervision, then you can be returned to prison for up to 1/2 of my original sentence. Or if you violate by committing a new felony, then you can be returned to prison for up to 1 year or the amount of time you have left on post-release control. It's automatically whichever of those is the longer period, and it's automatically consecutive to the sentence that you would receive for that new felony. We have $190 in restitution. I think, Mr. Ocello, what I'm inclined to do is to keep you on this case and set it for a hearing or a conference on judicial release in about 5 months. So you can go ahead and submit a periodic billing. I don't want that. I don't want you to get held up on getting paid. But Ms. Ido is going to reach out to you. We'll get a conference on judicial release, which will be in late July.
Do you want me to file a motion for judicial release so the court has record?
If you want to.
Whatever.
Probably makes sense.
Okay.
I mean, the law allows me to do a sua sponte judicial release.
Sure.
But might as well file a motion to keep a clean record.
Okay. Thank you.
Behave yourself while you're in the institution, Ms. Moses, or we don't even get over step 1. All right. You do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer to obtain a transcript or to pay the costs, those will all be provided to you at no charge. Hopefully, I will see you in 6 months, and we will get you over to a CBCF.
Thank you.
All right. That's all.
I'd say it might be PI.
Your Honor, did you want to go on record on this?
again, you might have residency requirements, but how many people are in your unit?
So I'm the only one that's in unit A, but there's 2 other people in this 3-bedroom.
Okay. I'll just say, okay. I don't know what that means. All right.
Basically, it's a 3-bedroom, but everybody pays rent individually, so it's charged per unit. So I'm in unit A.
It's charged per unit, but there's a common area that you all share.
Yes, living room and kitchen.
Yeah, okay. I got that. Then those other people are whatever they are. You have your.
They're correct, yes.
Okay, all right. Okay, so fill all that out, get that done. We'll see you next week. Okay.
All right, sounds
All
good.
right. I'm gonna make a note that
Okay.
she's a gopher,
Oh,
so that I'll remember. All right.
it wasn't my choice. My parents immigrated, okay?
Hey, no, that's what every kid says. It's my parents' fault. All right. Okay. You take care.
Thank you, you too.
I think that's it. That's all I have for you, counsel, for this morning.
That's it, Your Honor. Have a great weekend. Thank you.
You do the same.
Bye.
Bishop Pickering versus Mohammed Cisse.
Good morning, Your Honor. David Fanter on behalf of the plaintiff.
And Mohammed Cisse, he's here. I do see.
Good morning, sir.
Good morning. All right. What's the plaintiff's claim in this case?
Including court cost, the balance is $2,066.88.
All right, sir, how are you intending on getting that paid?
So I would need about 2 weeks, maybe until March 6th to pay that off because I'm a student at the University of Michigan, and then I have a huge balance on my student account. I'm paying for myself, and that has been putting a strain on my income. I work on campus only.
Okay.
Yeah.
What I'm going to suggest you do is that you contact Mr. Fantera's office and see if they can work something out with you in terms of a payment plan. Okay.
Okay.
I'll adjourn this out to February 27th, 2026 at 12 noon. That's an in-person. That's an in-person proceeding, so you'd have to come down to the courthouse. All
Okay.
right?
What's their contact, please? The contact of the
attorney. It's on your paperwork. There's a phone number there for David Fantera.
Okay.
Okay. And that's who you'd want to contact. The other thing is you might want to contact Hawk, see if you're eligible for any other type of assistance.
Okay. Do you have that contact, or is it on the packet that I received?
The Hawk number is 961 1999.
961 1999.
Okay, and that's area code 734. And then Mr. Fantera's office number is going to be on your paperwork.
Okay. Thank you, sir.
All right. Thank you. We'll see you next week then.
All right. Thank you. Bye.
Sandy McFiddish versus Donovan Alexander.
Good morning, Your Honor. David Fanter on behalf of the plaintiff.
Yes, hello. How you doing?
Okay, very good. How about yourself?
Good.
Okay. And what is plaintiff's claim in this case?
Including court cost, the balance is $2,485.
Sir, how are you intending on getting that paid?
Yes, I will be having that paid off by the 4th. And I will be moving out that same month too, when my lease is up on the 31st.
Of March?
Yes.
Okay. So you're gonna pay this, you think, by the 4th, and then your March rent also?
Yes.
Okay. Well, I'm going to suggest that you call the plaintiff's counsel's office, see if they can work out something regarding your move out and everything and the payment.
Okay.
And at least try to get you to that date. I'll adjourn this out to February 27th, 2026 at 12 noon. All right. Okay. And see if you can work it out. That proceeding that I just said is an in-person proceeding. So you'll have to come down to the courthouse. Okay, sir?
All right.
All right, thank you.
Thank you.
Red Line Apartments versus Anthony Ned.
Good morning, Your Honor. David Fantier on behalf of the plaintiff.
Ned, they are not checked in. If you'd like to take a default, do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do. Your Honor, I'm David Fantier. I'm the attorney for Red Line Apartments. As such, I'm familiar with the books and records they relate to this tenancy. The balance owing in this account is $1,803. Court costs of $173 for a total of $1,976. We'd ask for a judgment for possession with a writ after 10 days if that amount remains unpaid. Upon information and belief, defendant is not an infant, incompetent, nor in military service, and the apartment has been kept in reasonable repair and fit for the use intended during the term of the lease.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested. Writ to issue in 10 days. 103 South Huron LLC versus Joshua Bertram.
Good morning, Your Honor. David Fantier on behalf of the plaintiff.
Said he's here.
Is here.
Mr. Bertram?
He's not connected to audio.
He's not.
He's been here for a while. He is not yet connected.
All right. Can you send him a message? Mr. Bertram? He's just not connected.
Yeah, I saw he sent an email. He sent a chat to the court about an hour ago, I guess.
Yeah. It just says he's connecting the audio, but
Your Honor, I've dealt with Mr. Bertram before, and I can contact him. He has a relatively small balance of 400.
Okay. Got it. Why don't I do this? Let me just adjourn it out a week. Let you contact him and then do that. Can you let him know I'm adjourning it out to the 27th, 2026 at 12 noon?
And I will contact him, Your Honor.
All right, thank you. 103 South Huron LLC versus Jasmine Bowen.
Good morning, Your Honor. Oh, I think Mr. Bertram just sent us a text.
Yes, he did. He said he's at work. It went off my screen. He's using their laptop, but it's.
He'll try to connect through his phone.
Oh, he'll try to connect through his phone. Okay, you sent him a message, though.
I had already told him he could log out.
Oh, okay.
And I gave him the date.
Okay, if he comes in, we'll deal with him. Jasmine Bowen not here. Mr. Pantera, you may proceed.
In this case, there's rent owing in the amount of $1,530, court costs of $175 for a total amount owing of $1,705. We'd ask for a judgment for possession with a writ after 10 days if that amount remains unpaid. And defendant is not incompetent or in a military service, and the apartment has been kept in reasonable repair and fit for the use intended during the term of the lease.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested, writ to issue in 10 days. Mrs. Haverkamp versus Jack Lacassi. That matter is dismissed on plaintiff's motion without prejudice.
You know, I just want to say on that case, I filed my dismissal and then I got an appearance from an attorney about a half an hour later, and I emailed a copy of the dismissal to them and they said, okay.
Got it.
Okay. They said they would inform Mr. Lacassi. So I had already filed the dismissal when I got that.
Okay. I don't know that.
I don't think we have the
We never got an
correct.
We didn't get an appearance. Okay, very good. All right, thank you.
Thank you. Have a great weekend, Your Honor.
You do the same, sir. All right, court stands in recess.
This is the second time that the people have brought it before the court. The first time the court informed the people that it was a premature motion because I informed the court that I was double booked. I am booked to be in a trial on March 11th in the suit. That is also a capital case, which we scheduled back, I believe, in October. As far as today goes, we received a notice from the court in the Sioux that we are still on the docket, ready to go.
And that's why I don't like motions to adjourn until I know it's really going to go to trial. And I often call the other judges and say, hey, judge, is this one really likely to go to trial? Give me your input. So I'd like to wait till we get to the end because I don't want to adjourn and lose a trial date here in our courts. All right. And in that case, you said capital, is the defendant still in confinement?
He is on house arrest and tether.
Okay.
It is an older case. It's two counts of CSD first, incapacitated individual, and 1 count of CSD third.
Okay.
There's been no offers, so requested or made at this point. So it's my feeling that it's gonna go.
All right. Our trial here is set for March 10th. Is that correct, Madam Clerk?
Yeah.
All right, Ms. Satawa, your response to the motion to adjourn?
Your Honor, we have no objection to the request to adjourn. We have been in the process of getting our experts report. It has not been, we don't have it yet, and we have obviously not been able to turn it over to the people. In addition to that, we have been having some fruitful discussions, and so we're hoping for more time.
All right, sounds good. Thank you. Well, again, it wasn't intended to be rude when I denied the stipulated request. It's just because I want to make sure I keep cases moving. This also gives me the opportunity to talk to the defendants in person and hear from the judge. My goal is to get the case moving, get the case done. However, when there is a reasonable, good cause request to adjourn a trial, then I'll grant it. There are also things that put other cases forward versus others. And since neither you or Ms. Connors are in pretrial custody, your case is not the top. So I'm going to go ahead and grant the motion to adjourn. We'll have it reset on the trial docket. There will be another final pretrial conference. All right, so to both there's another case that has a very similar name, and I don't want to call you that person's name, and Mr. Allen. So Mr. Allen and Ms. Connor, when I have final pretrial conferences, final pretrial conferences are the last date in which we're going to take, or I will allow an acceptance of a plea underneath a pretrial agreement. And then if we don't have one on a final pretrial conference date, then the case is going to trial. The only thing I'd let you do is plead straight up on the trial date. Now, please know, Mr. Allen and Ms. Connor, that is not to force anybody to enter into a pretrial agreement. In fact, my policy, I think, helps defendants just as much as it does me. You want to know on that day, is the offer going to get any better? And the answer is no. I don't want you waiting till the very last minute, freaking out and, oh my gosh, am I going to get this? You know, on that day, that's the best offer that people are going to give to you. And also because there are a lot of things that have to happen in the background. You have to have about 120 potential jurors come in. They all have to rearrange their schedules, get somebody to pick up mom, take grandma to the hospital, take care of the kids, get somebody to stay home from work so the other spouse can come, and all that. Plus, subpoenas have to be issued, witnesses have to be brought here, and there's a lot of moving parts. And before I make those parts move, I tell the attorneys, make sure you have exhausted all your brilliant negotiating skills and tactics. That, again, not only helps you, but also helps the court. And On average, I can do about 24 trials in a given year covering 2 counties with circuit court criminal cases. And if I were to allow deals on the trial date, I'd lose the opportunity to do a trial. And therefore, the people of Wexford and Missaukee County lose a trial date too. So please know, I don't know anything else about the file other than the charges. I have no opinions about what you should do or how the case should resolve. I'm just here. I run Tiger Stadium, also known as the Circuit Court, and I want to watch somebody play baseball that day. Okay, which is always the funniest analogy for me to give because I cannot stand baseball. All right, thank you. All right, so on that file, we've covered the motions to adjourn. There is something else, and do you want to talk about joinder or severance, or do you want to put together a written motion to put it all together in a better package? I don't particularly care.
I mean, I can argue it off of my draft if the court wants to hear it.
But it all, and now that means I turn to Ms. McIntyre and say, because I know you have the right to have notice. So,
Your Honor, honestly, it would be my preference if it were written, and so I have an opportunity to respond.
Sure, I don't know.
I mean, depending on what she says, I don't know what my answer is going to be. I mean, Ms. Satawa could make a, really brilliant argument, and I could say, makes sense. So.
Well, if there's anyone who can, it's probably Ms. Satawa.
So I would prefer written, Your Honor.
No problem, that's fine. And who knows, maybe in the preparation of that and exchanges, you all might go, oh my gosh, that makes sense, or maybe it'll help resolve the case. So it's probably best that I don't address it now. But I wanted to make sure that the counsel, the attorneys, and that's right, parties that heard us talk about that a little bit. Again, I think it's the first time I've met you, Ms. Connor and Mr. Allen. Maybe I'm wrong, but I think it is. If I haven't, that's a good thing. If I don't recognize you. All right, anything else you think we need to address, Ms. Satawa, today?
No, Your Honor.
All right, Mr. Harrison, on your file?
I'm fine as well, Your Honor.
All right, thank you. I forgot to ask you, Ms. Connor, are you able to see and hear us today?
Yeah, yes, Your Honor.
I don't want to turn this way since you signed it. All right, Ms. Connor, hope you're feeling better. We'll see you all in a couple weeks whenever I get a new docket schedule. Anything else, Ms. McIntyre?
Your Honor, just for clarification, because I'm a rookie in front of your court, so the court is going to give us another pre-trial date without a jury trial date. The jury trial date will be determined at that pre-trial date.
Nope, you will get both. You'll get a date for both.
Okay.
And then we'll deal with, potential adjournment, things like that if we need it.
Potential conflicts again.
It'll probably, you won't be back here till at least probably a month for a final pre-trial date on a Friday.
Okay, I just was wondering in terms of a trial date, like if there can be, I don't know how the court schedules it, if there's like emails that go out and say, do these dates work? Because I know there's other trials that have been scheduled, and I also have some medical issues going on that have to be dealt with, so.
Okay. All right, well, the answer is I just pick dates.
Okay. Yeah.
Because if I ever try to coordinate dates,
I know it's a circus.
and I see it with my civil cases, it takes forever, and I'm just not going to do it.
Okay, fair enough.
Yes, ma'am.
I am 100% not available from April 28th to May 13th.
Would you maybe go?
I can send an email.
Yeah, just do that to Nicole. Okay. Nicole's the one that handles that. So that's perfectly fine.
Okay.
Going someplace fun?
South Africa.
Oh, well, can we all go?
I don't know. Well, anyway, that's fair and reasonable, but if you guys have a good excuse, that's fine. And again, if I just keep the things going, sometimes a case resolves and I keep you all thinking about it. I do not like cases slipping on to the back burner. And I know you all are quite busy. So we'll see, we'll deal with it. Send a message to Nicole. And she'll take that in consideration, setting it out, as long as there's no objection. All right, thank you, folks.
Thank you, Judge.
We're adjourned.
Okay.
Hold on. Miss Atawa and Miss McNair, they aren't joined actually right now.
They are not
No.
just running at the same time?
We have them set for the same dates. And I set about 5 cases for trials on any given trial date. Right, so today I've got 5 or 6 cases set for the same trial date. Some will plead, some won't.
Okay.
So right now, you're not even joined unless you ask for joinder.
Okay, so I would have to do a motion for joiner.
There you go.
Okay,
All right, thank you.
thank you.
I did not know that. Thank you, Madam Clerk.
I didn't realize that either.
I guess they
Because they were
need to
charged as codependent, so.
Well.
You're back.
Huh?
I brought the schedule back that I could read.
No.
No?
I took it to my office.
Okay.
If you want.
Thanks. Thank you very much. Good.
Did I have some attention? Oh, wait, no. I've got Mr. Carnes and Mr. Dodge. Let's take care of that. Joshua James something. Johnson, thank you. Our next file is people of the state of Michigan versus Joshua James Johnson. File number is 25-14115. Appearances from counsel, please.
Nate Carnes on behalf of the people. Mark Dodge on behalf of Mr. Johnson.
Mr. Johnson is here. That's at the fence table. You all may be seated. Nancy, I need an exhibit sticker, please.
Sure.
We're here today for a final pretrial conference.
Your Honor, may I?
Mr. Dodge, did you have an, oh, no, I got it. All right, so we're here today for a final pretrial conference. We conducted that in chambers, myself and counsel. They informed me that today there will be a resolution. Mr. Carnes, why don't you go ahead and state the details for this pretrial agreement today?
Yes, Your Honor, thank you. It's my understanding that the defendant will be entering a no contest plea to an added charge of assault with intent to commit penetration. That is a 10-year felony. People will be dismissing the charged CSC in the 3rd degree. There's also a Killebrew agreement that the defendant will be placed on a delay of sentence of up to 1 year. During the period of that delay, he will participate in the youth sex offender treatment program in Kent County, or rather in counseling under that program. That is abbreviated YSOTP. And if he completes that program or is still compliant with him at the close of the delay, then he'd be permitted to withdraw the plea to this charge and enter a no contest plea to sexual conduct in the 4th degree. There's a further Killebrew agreement that there would be no additional upfront jail at the time of sentencing.
All right, thank you. Mr. Dodge, is that a complete accurate statement of the pretrial agreement between the parties?
Yes, it is, Your Honor.
All right, thank you. All right, Mr. Johnson, is that how you wish to resolve today's case?
Yes, sir.
Please raise your right hand. Swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, and nothing but the truth. You may go ahead and take your seat. Make sure that when we're talking today that you answer loudly enough so that Nancy in front can hear you and I can hear you, okay? She needs to be able to take down every word you say. Looking back at a date range of September 1st to December 31st, back in 2024, were you on probation, parole at that time? All right. Were you on bond pending any felony charges anywhere else?
No.
Thank you. All right, Mr. Johnson, you were currently charged on a felony information, which is just simply a piece of paper, and you were charged there with a single count. That single count is a charge of criminal sexual conduct in the third degree upon a person aged between 13 and 15 years old. Now, that is a felony that is punishable by 15 years and requires mandatory AIDS and STD testing and DNA taken upon arrest. Plus, it is a Tier 3 Sex Offender Registration Act case, which would require sex offender registration to be conducted throughout the rest of your lifetime. And they are done, I can't remember if they're annually? No, they're done quarterly. Anyways. Also, you can be subject to periods of probation as well, right? You understand that so far?
Yes.
Now, I'm told today that you're going to enter a plea of no contest to another charge. Let's talk about what a no contest means. Typically, at a guilty plea, I have to have the defendant answer a bunch of questions to explain why he or she is guilty of that offense. So they have to tell me what it is that they did. Now, a no contest plea is slightly different. Instead of requiring the defendant to make a statement, I'm going to look at something else, such as a police report, or in this case, the preliminary examination transcript. I can only take a no contest plea in a couple situations. One is potential civil liability. In other words, the person could be sued. And from what the attorneys have told me, that's the theory that we're using with today. And I see both counsel shaking their head yes. All right. But a no contest plea has largely the same impact as a guilty plea. We're going to talk about that. If you enter a no contest plea, and I accept that plea, you would not have a trial. Does that make sense, sir?
Yes.
Now, that means you would also be given up certain rights that you would have at a trial. That includes the right to be tried by a jury, the right to be tried without a jury if you chose, the court and the prosecutor consented, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you appear at the trial, the right to question and cross-examine those witnesses against you, the right to have the court order any witnesses you may have for defense to appear at the trial, the right to remain silent during the trial, and the right to not have a lawsuits against you. Do you understand those rights?
Yes.
Now, actually, I know you probably have heard them already because your counsel handed me a form that at the top says advice of rights, and then it appears to have your signature. I'm holding it up. Is that your signature at the bottom? All right. So did you read through all this information?
Yes.
And even though I also just went over it with you, did you understand what you read?
Yes.
And again, even more importantly, you understand that by pleading no contest, if I accept that plea, you will be forever waiving these rights as they apply to this particular case.
Yes.
So now we're going to talk a little bit more about that pretrial agreement. I told you what you're charged with, but I didn't go over what you're going to plead no contest to. I just said it in a preposition. I haven't gone over to what you will be pleading to. So I'm told today you're going to plead no contest to an added count 2. And if I accept that plea, count 1 will be dismissed. Now that added count 2 is a charge we call assault with intent to commit a criminal sexual penetration. Now that is a felony punishable by, instead of 15 years, up to 10 years. Also required sex offender registration for life, and it's done, I think, quarterly for that offense. Now, even though you might say 15 years to 10, does it seem like a whole lot? Well, it actually also goes down on what's called Michigan sentencing guidelines. It goes from a B grade offense to a D grade offense. It also impacts potential sentencing. Now, I'm told that there's another portion of this agreement. It's probably the most important for you. The agreement is that I would place you on what's called a delay of sentence. A delay of sentence allows me to basically not finalize the case, not finalize the sentence. Imagine if the sentence means when I whack this piece of marble with a gavel. Well, I don't do that yet. I basically hold the gavel and put it off to the side and bring you back in about a year. And over that year, you're not on probation, but you have terms that are very similar to probation. That may include no contact orders. It may include no alcohol, drug testing, things like that, and also that you can't violate the law. Well, one of the terms or conditions that would be a part of this is that you would be ordered to remain compliant with this YSOTP program down in Kent County, which, as I understand, stands for something to the effect of Youthful Sex Offender Training Program. That's what the P stands for. And if you are compliant with your terms and conditions of that period of deferral or delay, then you would have the right to withdraw your plea to the count 2 that I've talked about, that 10-year felony, and instead enter a plea of no contest to another charge called criminal sexual conduct in the 4th degree. Now, that is a high court misdemeanor punishable by up to 2 years and or up to $2,000. And additionally, there's sex offender registration requirements as well, but they're a lot less. There, it would be biannual registration done for a period of 25 years. And it's what we call a tier 2 registration versus a tier 3, which is the most serious. All right. Do you understand all that? All right, let's talk a little bit about what that sentence means, that agreement means. We call it a Killebrew agreement. Killebrew is just the name of an appellate case here in the state of Michigan. And what it says is that you and the prosecutor, along with your attorney, of course, have reached an agreement. And if at the time of sentencing I don't go along with it, you would have the right to withdraw your plea. You might be sitting there thinking, well, it sounds like the judge is going to go along with it. There's probably a pretty good chance I will, but I don't know anything about it. Now, why I'm told that you don't really have any prior criminal history and you don't look old enough to have any significant criminal history. Sometimes, I don't know, you might actually be wanted for some case across the world. Maybe you've been running drugs and it's across off of whatever it's called now. But that's why I don't make that decision. But I really want to see how you find out more information about it. So if I don't go along with it, you can withdraw your plea. If I do go along with it, then we're going to continue to go along this program that I just got over with you. You understand?
Yes.
All right. Now, earlier I went over your rights with you, and then one more thing. Have there been any other promises, threats, or inducements of force or compel you to make this plea today that we haven't talked about?
No.
Okay. I also like to cover here with Mr. Carnes. Mr. Carnes, you've gone over the terms and conditions of this pretrial agreement with the complainant and her mother.
Yes, sir. That's
and as I understand it, they are aware of it, the terms, and are in support of the resolution. Is that correct?
That's correct.
All right. Thank you. All right. So, Mr. Johnson also as you've probably talked to your attorney, he's probably giving you all kinds of information about sentencing guidelines and potential sentencings and things like that. Has he made any promise to you as to what exactly I will do?
No.
You've been able to speak with Mr. Dodge about this case and the charges, and you've looked at the police report and transcripts. Is that right?
Yes.
Okay, good. And you've gone to him and he's been able to answer all your questions for you?
Yes.
Are you satisfied with his counsel?
Yes.
And you believe that his advice in this resolution today is in your best interest?
Yes.
So I'm now going to ask for your plea. Now, I'm going to tell you what I expect you to say. It doesn't mean that you have to say it. But if I don't give you this warning, everybody in that chair says the wrong thing. So I expect when I ask you what your plea is, it'll be no contest, right? So don't say guilty. So As to added count 2, assault with intent to commit to sexual penetration. How do you plead? All right. Before the court can accept that no contest plea, I need to take a look at some information. And as the parties, as the counsel advised me in chambers, we're going to enter as the basis People's Exhibit number 1, which I have in my hands. This is the preliminary examination transcript. The prelim was held on August 18th of 2025 before the Honorable Court of Wiggins of the 84th District Court. Mr. Carnes, are you asking the court to accept this exhibit for the basis of the plea?
Yes, Your Honor.
And Mr. Dodge, does the defense so stipulate for its use for the plea and plea and sentencing?
Yes, Your Honor.
People's Exhibit number 1 is hereby admitted. I did look through that. It's not all that long. I did read it in chambers before coming out today. Mr. Carnes, do you believe the interests of justice do not require the defendant to recite a factual basis?
Yes, for potential civil liability, Your Honor.
And do you believe that the contents of People's Exhibit 1 satisfy the elements for the added count 2?
Yes, Your Honor.
Are you aware of any other promises, threats, inducements today?
Okay.
And you believe the court supplies Mr. Pearl 6.302?
Yes, Your Honor.
Mr. Dodge, do you agree with all what he said?
Yes, Your Honor.
All right, good, thank you. Well, the court agrees in the interest of justice based upon what the parties have told me is really non-existent prior criminal history, the facts of the case, and what I've read in here. Again, the interests of justice do not require the defendant to recite a factual basis. The court also finds the defendant's plea today has been made freely, knowingly, and voluntarily. The court further finds that the information contained in the report, again, satisfies the elements for the added count 2. Therefore, the defendant is found guilty of added count 2, assault with intent to commit a criminal sexual penetration. Mr. Johnson, what's going to happen next is you're going to leave this courtroom and go downstairs to the probation and parole office, also known as the Michigan Department of Corrections. Now, I think you have a tether, right?
Yes.
So you got that at the office called the Community Corrections Office downstairs. No? Where'd you get it?
Through Manistee.
Oh, okay.
The GPS applies to this county.
All right. Well, was there another case in Manistee? That's right. I recall that from a few months ago. All right. So when you leave my courtroom, sorry, she never said my courtroom. People's Court. Then I said the People's Court, and it sounds like it's a TV show. You're going to go down the elevator, take it all the way down to the ground floor. When you step out, do a sharp button hook to the right. At the end of that hallway is a door. Go through the door. It always sounds like I'm talking about a Dungeons and Dragons. Go through the door, but go through it. At the end of the hallway on your left-hand side is the probation and parole office, also called the Michigan Department of Corrections. When you go in that hallway, there's only 3 windows. If you ask anybody, hey, where do I go from Judge Elmore's court? They'll tell you, okay? Now, they're going to give you a packet of information. You're going to complete that packet, and then you're going to turn it in. You'll also be subject to an interview. That interview will be with an agent from the office. You have the right to have Mr. Dodge present during that interview. Now, this report that they're going to prepare will talk about the pretrial agreement, what you were charged with, what you pled to, information about any prior criminal history you do or don't have. It'll also include the information that you provide while you're reporting this information to them. It could include a statement from any victim in the case. It will also include something called a scoring of the Michigan sentencing guidelines. Now, these Michigan sentencing guidelines are not mandatory. They just give the court a tool to help establish a reasonable and proportionate sentence. I just noticed there's one issue that I failed to cover in the pretrial agreement, but I'll get it in just a second, in case you're looking it up. All right. It will also include a recommendation as to what they think the court should do. Please keep in mind, it is strictly a recommendation. Nothing in there is mandatory. I alone get to make that decision. Understand, Mr. Johnson?
Yes.
So you're gonna leave here, go down there, get a packet, fill it out, turn it back in, schedule an interview, and then Mr. Dodge is gonna have to meet with you prior to coming back to this court, because he'll get a copy of that report, and the two of you need to go over it before I give a sentence or decide what to do. The reason is each side can come back and say, hey, judge, this is wrong. This name is spelled incorrectly. This year is incorrect or whatever. Okay. Now, the one thing I forgot was one of the terms or conditions of this Killebrew agreement is after, if you're successful with that delay period and you withdraw your plea and then we enter a plea to the reduced charge of CSC 4, there was also a term of the agreement that there wouldn't be any additional initial jail. Additional means obviously you get credit for any time you served in jail, so I give you that credit. But you wouldn't have to serve any additional jail. That means that if I'll put you on probation, if you violate probation, then I can get you jail. Okay, does that make sense?
Yes.
Do you still wish to go proceed with the plea?
Yes.
All right, the court reaffirms its findings. Anything else today, Mr. Carnes?
Your Honor, Mr. Johnson and I were discussing, he wanted to bring a bond motion, and I think we've reached an agreement whereby Mr. Johnson has a radius, and I think it's fair to reduce that radius to 1 mile to the victim's house and school. He's prohibited from coming within 1 mile of both locations. I think it's bigger than that right now. I have no objection to reducing it to 1 mile.
Is that correct, Mr. Dyer?
Yes, it's been a little bit of a gray area on what the radius is, but I think we agree.
The court will modify the terms and conditions of the bond that the GPS radius will be 1 mile from the victim's residence. Mr. Carnes, hold on.
Yeah, and her school.
And her school. And that school is?
I'm pretty sure it's Mesick High School.
Right, Mesick High School, and then I'm not going to state her address on the record out loud here, but if you would please make sure that clerk has it. Let me take a quick look, maybe it's on it. I don't see it listed on the register of actions, so just make sure Madam Clerk has that address.
Yes, Your Honor.
All right, thank you very much. Anything else, Mr. Dodge?
No, thank you very much, Your Honor.
Good. Otherwise, all your bond conditions remain in effect. Mr. Johnson, don't forget, go downstairs, button hook to the right, walk straight. Thank you. We're adjourned. Yep.
Joe.
I'm Jeff Harrison. I'm here on behalf of Dave Hill. He's next to me at the table.
All right, thank you. You may be seated. All right, we are here today for a final pre-trial conference. What are we doing today, Mr. Evans?
Your Honor, I believe Mr. Hill is going to enter a plea under the following terms. As to the charges, the offer is to plead guilty to counts 1 and 2 as a habitual offender, second offense. In exchange for that plea, count 3 will be dismissed and the habitual offender, third offense, will be dismissed. Under the terms of Killebrew and Briggs, there is a further sentencing agreement. Number 1, dependent on Mr. Hill making his monthly payments up until the time of sentencing. And that is for a 11-month delay of sentence. If during that period of delay, Mr. Hill can reduce the arrears to $17,500 or less, the conviction will enter for one count of attempt failure to pay child support, and the habitual offender and original charges will be dismissed. If he's able to reduce the arrears during that period to 0, then one count of disorderly person will enter.
Mr. Harrison?
That comports with our understanding of the matter. As I discussed with Mr. Hill, the only thing that I perhaps failed to address with him would be his obligation to pay on his current child support obligation between now and sentencing. But we're willing to accommodate that to the extent possible as well.
Mr. Hill, is that how you wish to resolve today's case? Okay. You swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, nothing but the truth? Yes. Sir, you may lawyer. All right. Mr. Hill, you are currently charged on a felony information with 3 counts. Each count is a charge of failure to pay child support. Each count is a felony punishable by up to 4 years and or up to $2,000. Plus, there's a sentencing enhancement called the 4th habitual offender enhancement. That could, within the discretion of the court, increase the maximum punishment from up to 4 years to up to 15 years. That would also have an impact on the sentencing guidelines. I'm told today that you're going to plead guilty to count 1 and count 2, which again are failure to pay child support. Each again are a felony. Each are punishable by up to 4 years and or $2,000. And you'd also be pleading, and then count 3 would be dismissed. And the habitual offender 4th would be dismissed, but you'd be pleading as a 2nd habitual felony offender. Now, the impact of that is, it means that at the time of sentencing, within the discretion of the court, that maximum punishment for counts 1 and 2 could be increased from up to 4 years to up to 6 years, and from up to $2,000 up to $3,000 in fines and or costs. So far, is that what you understood you were doing? Yes. Now, if I accept that plea, the other portion of it, there's an agreement between you and the prosecutor as the sentencing. This is called a Killebrew agreement. A Killebrew agreement is just an agreement where you and the prosecutor's office have made a deal. And that is, the deal says that I will do something for you at sentencing. And but if I don't go along with it, then you could withdraw your plea and come back to this stage of proceedings and continue negotiating or just go to trial. Now, I have no idea whether or not I'm going to accept it because I don't know you. If I do know you and I have seen you, I apologize, I don't recall. But let's see what we got. The agreement is that you would continue to make your monthly payments. Means from now and until the end of a delay. Now, a delay is, what's going to happen is, right, if I take the plea today and I accept it, we'll set this for sentencing on a Monday morning, typically in about 4 to 5 weeks from coming from this Monday, upcoming Monday. Then at that time, if I agree, I'm going to place you on a delay of sentence for up to a year. Now, it looks like probation, sounds like probation, and talks like probation, but it's not really probation technically, even though I give you the same terms and conditions that I would for a probationer. They'll be not to violate any criminal law, not to drugs and alcohol testing, if I believe that. I don't know anything about you, but if you had any issues with substance use disorder, I could make that a term or condition. And there'll be other things like continue to pay on your child support. And this delay is for up to 1 year. That means that I generally push these out a little bit to make sure that you're compliant. So after that period of delay, if you've been able to pay the arrears down, which at least at the time of the felony information was $34,840.05, if you reduce that down to $17,500, then you would withdraw your plea to counts 1 and 2, and then you would enter a plea to an added count 4 of attempting to fail to pay child support, which would make that a high court misdemeanor punishable by up to 2 years and or $1,000. Or option two, if you pay that down from the $34,840 down to zero, don't forget the 5 cents, then you could withdraw your pleas again to count 1 and 2, and then enter a plea to the added count 4 of disorderly person. Now, this disorderly person charge is one of those, it's kind of like a hodgepodge, and it's got 1 in there for failing to care for a child. Anyways, it's a misdemeanor punishable by up to 93 days and or up to $500 in fines and costs. Hold on, did I get that right, Mr. Evans?
Yes, Your Honor. I just noticed a tiny little rumble with the 34, which is the amount contained on the information. Currently, arrears are down to 31,822. So I thought I'd just pass that on.
You understand? All I'm doing is looking at what.
Yeah, I know.
All right, good enough. Thank
That's
you.
what we were just covering too.
I'm glad you guys are. I'm glad you're making those payments. Thank you. So far, Mr. Hill, has what I described to you, is that what you understood to be the term sheet? Good. Now, by entering a plea of guilty today, if I accept that plea, you're not going to have a trial of any kind. Does that make sense?
Yes.
Now, I'm holding up a piece of paper that Mr. Harrison provided to me. At the top, it says advice of rights. At the bottom, it appears to have your signature. Is that your signature?
Yes.
Did you read through these rights before signing?
Yes, I did.
And did you understand what you read?
Yes.
And even more importantly, once again, you understand that if you enter a plea of guilty and I accept that plea, you'll be forever waiving these rights as it applies to this particular case.
Yes, sir.
Additionally, you'll be given up the right to claim that the plea was a result of any other promise, threat, or inducement not told to me today. Have there been any other promises, threats, inducements? Be making this plea of your own free choice?
Yes.
Now, Mr. Harrison's probably talked to you about potential sentencing guidelines, how those apply to felonies, high court misdemeanors, how they don't apply to regular misdemeanors. He's probably trying to give you an idea of possible sentencing outcomes. Is that right? I want to highlight for you first that Michigan sentencing guidelines are not mandatory. They are a valuable tool courts must use, but the actual scoring they give is just really that. It's just a recommendation. So has anyone, so he hasn't promised you any actual sentences? All right, good enough. So has he been able to answer all your questions about the case? Yep. Yes?
Yes.
That's okay. And are you satisfied with his representation?
Yes, sir.
And you believe that what you're doing today is in your best interest?
Yes.
All right, good. Any questions before I take the plea?
No, sir.
As to counts 1 and 2, failure to pay child support, how do you plead?
Guilty.
And before I go into having you, well, no, I'll do it this way. That's between 2 date ranges. Count 1 applies to a date range of August 1st of 2021 and February 29th of 2022. And were you ordered to pay child support for children here in Westford County?
Yes.
And was it one child?
One.
And so for that period of time, you had failed to make those payments?
Yes.
And those payments were ordered by a court that you had to make?
Yes.
For count 2, it covered a date range of April 1st of 2022 through October 31st of 2022. Is it true that you still failed to make those payments of child support and those payments were ordered by a court?
Yes.
All right, thank you. Is it also true that for the second habitual felony enhancement that you were previously convicted of failing to pay child support? Looks like back on April 23rd of 2021. Is that correct?
Yes.
Oh, that was here, so it would have been me.
Yes.
Apologize, I don't remember.
It's okay.
But it's always a good thing if I don't remember your name.
Right.
Yeah.
Way better.
Yeah. I say it all the time. If I call the case and use your middle name without reading it, that's a bad sign. But today I had to read it. All right. Mr. Evans, you believe the defendant provided the factual basis?
I do, Your Honor.
Are you aware of any other promises, threats, or inducements, sir?
I am not.
And you believe the court complies with Mission Rule 62302?
It appears it has, Your Honor.
Great. Mr. Harrison, do you agree with all that?
I do indeed, Your Honor.
So do I. The court finds the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant under oath on the record satisfies the elements for the offenses. Therefore, the defendant is found guilty of count 1 and count 2 as a second habitual felony offender. Now, Mr. Hill, what will happen again is something that's happened here in the past for you, is we're going to have a pre-sentence investigation report prepared by an agent of the Michigan Department of Corrections. That report will include a description of the offense, description of the pre-trial agreement, statements or information you may provide while it's being prepared. It will also include information about prior criminal history and how you've done on bond, probation, parole, any of those things in the past. It will also include a score into the guidelines, which again, I highlight are not mandatory. It will also make a recommendation as to the sentence. Please keep in mind it is merely a recommendation as I make the determinations. And if for some reason I do not go along with this agreement on the sentence portion, you would have the right to withdraw your plea at the next court date. So when you leave here, you're going to go downstairs to their office, take the elevator all the way down, step out to a button up to the right, walk in about 10 paces, open the door, don't walk into the door, it'll hurt you, and then walk down the hallway. It's on the second window on the left-hand side. You understand?
Yes.
All right. Now, I think I covered it all. Any objection to continuation of bond, Mr. Evans?
No, thank you, Your Honor.
Mr. Hill, your bond conditions still remain in effect. I don't know what they are, but I can look at them, but I know you got them.
I know.
Good. Mr. Harrison, anything further?
Nothing further, Your Honor. Thank you.
We're adjourned.
Thank you, Your Honor. Thank you, counsel.
Thank you, Judge.
Yeah.
Yeah.
There was one.
You already pled guilty.
Yeah, I pled guilty. So we're-
Hey, Judge, guess what? My computer won't connect to the internet. Sound familiar?
Yeah.
I think it's my computer too, unfortunately. So I get to,
Is it because, do you have to have a UT card? The whole thing?
we have all seeing that District Court for County of Washington, State of Michigan is now back in session. The Honorable Judge Simpson.
You may be seated. Court does call the case of Clara Gahan versus Holly Ellison.
Good afternoon, Your Honor. This is Ike Start, student attorney at the University of Michigan, and I'm requesting to appear on behalf of Ms. Ellison, due to Michigan Court Rule 8.120 under the supervision of Attorney David Santacruz.
Permission to practice is granted.
Thank you.
No.
No, she is unrepresented. She is not present. This is defendant's motion.
Yes, this is defendant's motion. But I don't have the plaintiff. So what do you want to do?
If you want to hear the motion, Your Honor, I'm willing to argue it.
I'll hear the motion, but what would you like the court to do? I don't have the other side here.
Yeah, we could go forward with the motion.
All right, go ahead.
So, Your Honor, this case was supposed to be resolved by conditional order of dismissal, which was entered by this court on November 21, 2025, and the relevant terms of that the conditional order of dismissal was that my client, Ms. Ellison, was to vacate the property by the end of the year and also facilitates funding for Ms. Gannon. And then in return, Ms. Gannon was supposed to return Ms. Ellison's security deposit within 30 days of vacating the premises as required by law. So Ms. Ellison vacated the property. That's my client, vacated the property on December 5th, 2025. And that 30-day period for plaintiffs to return the security deposit was ended on January 4, 2026. And we had not received the security deposit by that date. So this motion, we have two claims in this motion. First is that plaintiff violated the conditional order of dismissal. And we had not received the security deposit at the time of filing, but since we have received that security deposit after filing, and so the remedy for the breach of the conditional order was simply to get the amount of the security deposit, which we now have. That being said, we have a second claim, which is that plaintiff violated the Security Deposit Act. MCL 5546132 states that the failure of the landlord to return the tenant's security deposit within 30 days of termination of occupancy makes
Did your client supply notice? Or
yes, Your Honor.
a forwarding address?
Yes, Your Honor. She supplied her forwarding address on the day that she moved out via email. And that, I believe that's attached as an exhibit on the motion if you'd like to see that email.
Wouldn't all of the provisions of the Security Deposit Act having been waived if you are placing it in the confines of a conditional order of dismissal?
No, Your Honor. The conditional order of dismissal in no way waived the statutory obligations that would make the plaintiff.
Does it say that in the conditional order of dismissal?
Let me take a look. That's also attached as Exhibit A. Let's see. It certainly gives action to reopen the case and to reinstate the case and for the court to issue a judgment if the terms of this order were not complied with. So I would argue that the conditional order in no way waived. I would say it's pretty clear from the text that it did not waive the statutory obligations of plaintiff. So continuing on, the under MCL 554613, plaintiff is liable to my client, Ms. Ellison, for double the amount of her security deposit retained. And Ms. Ellison,
when was the security deposit returned?
It was after the date of the filing, and this was filed on January 29, 2026. So I think it was shortly thereafter. So end of January, maybe early February. But in the meantime, my client was threatened by her new landlord because she didn't have the money to pay for rent. She was relying on the security deposit to be returned, and so this caused great hardship to her, a fallout with her new landlord, and potential more litigation. And she was very anxious about being homeless.
Was there more litigation that ensued?
No, Your Honor.
It was just her worry that she would be sued.
That's correct, and Miss Ellison contends that she relied on the fact that Miss Gannon would comply with the law and return her security deposit. So when she moved to the new address, she told her landlord that, I'll have the money by January at the latest, January 4, and then January turned into February. And the landlord, in my understanding, was days away from initiating litigation, and my client was anxious about being homeless again, her and her son. And this was all because Ms. Gannon failed to abide by the law. And so Ms. Ellison contends that she is entitled under the statute, and that's the statute. The purpose of the statute is to protect against this exact thing, which is that a tenant would rely on the word of of the landlord, but and then the landlord not following through. And I would just say one more thing is that counsel or myself tried to reach out to Ms. Gannon many times. When it came to our part, our obligations under the conditional order dismissal, Ms. Gannon was very, very willing to communicate, always answering our calls and emails. But as soon as she got her money and my client moved out of the apartment, it was radio silence from Ms. Gannon. I emailed her, I called her, I left her voicemails with nothing in response for over a month. And that caused great hardship to my client. And so my client, Ms. Ellison, requested this court reopens the case because it was previously closed under the conditional order of dismissal and then award.
But why wouldn't I consider all of the provisions or the provisions of the Security Deposit Act were, because you'd almost have to reserve that, wouldn't you? Because everything in this conditional order of dismissal circumvents the Security Deposit Act.
No, I don't think so, Your Honor. I think.
I know you don't think so, but wouldn't you have to reserve it? Well, I mean, give me a reason why you wouldn't have to reserve your rights under the Security Deposit Act. You're altering it. You're altering that statute in the confines of this order. For example, it's 4 days and you limited it to 3 days for the time period at which to do that. There's no provision that's laid out. And also you're saying that she's agreeing just to return the security deposit. Just return the security deposit. All of the provisions that would apply within the Security Deposit Act as to what the landlord could do have been altered.
So, Your Honor, if I may jump in for 1 second here.
No, he's doing just fine losing this by himself. Go ahead.
So I would say that normal practice is if you've got a COD that could take more than 50 whatever days it is to be paid out on, that you have to explicitly waive the law. But without an explicit waiver, it obtains. So that was our approach.
But you changed what's in the statute. It's usually a 4-day period, right, to receive forwarding address.
Well, we just did it faster, but yeah.
But you've altered the statute.
But you're
by the 3 days. You've also altered the rights of the landlord to do anything, because even as I read the terms of this, irrespective of whether or not there's damage, irrespective of anything, the security deposit is coming back. That's not the way the statute reads. You've altered the statute, but now you want to enforce the remedy provision that's contained in the statute.
I'm sorry, you're breaking up a little bit, but I don't read the conditional order of dismissal to really do anything other than to benefit the plaintiff. So, and the law is the law, and if we gave more grace.
No, the law is the law, and the law says that if she gives that notice, that if the landlord has damages, the landlord can do something. The landlord, with regard to that security deposit, the landlord with this conditional dismissal can do nothing but return that security deposit. You've altered the statute and the remedies provided to each party under the statute, but now want to enforce the other remedy provision within the statute. I don't think that's how it works. If what you wanted is to say that given everything we've done here, that if you don't return it within 30 days, that she'd be entitled to double the amount, then it should have been said, but it's not said.
Understood, Your Honor. My client left at a timely manner. I mean, the fact if this might be a different case if my client left the place a mess and and there was
but it wouldn't matter.
Damages.
but it wouldn't matter. That's what I'm getting at. It doesn't matter. She could have destroyed the whole thing. But regardless, under the provisions of this conditional order dismissal, that security deposit had to come back, which is not what the statute envisioned. You can keep shaking your head, but tell me where I'm wrong.
Well, I don't think that this conditional order of dismissal would force her to return the security deposit, even if there was damages. I don't think this conditional order dismissal supersedes the law. That's my contention.
Hold on a second, counsel. How do you read that? Look at your paragraph 7. If the defendant vacates the lease premises timely under the terms of this order, plaintiff shall return the defendant's security deposit in the amount of to defendant's checking account or send it via email by forwarding to the address within 30 days of the date that it vacates. Tell me how what you're proposing could even happen.
Well, under the statute, Your Honor, I don't think that the wording that we use in this conditional order supersedes the law written by the legislature. This was just an agreement to get this case settled. I don't.
Yes, you have, because you already altered it with the 3 days versus 4 days. You already altered it, making it mandatory to return it, irrespective of anything else. There's no exception here. There's nothing. There's no exception that if gas, utilities, or anything else is owed, may not have been in this case, but there's no exception in here that if something else is owed, they could take it out of the security deposit. This security deposit was coming back regardless. And the rest of the rights, this court would rule as to what would pertain under that security deposit were not retained or preserved or reserved. And so therefore, your motion to request your motion to do that, I don't think is equitable and fair under the circumstances, and the court does not believe that that is the intent of the order that I signed. And so therefore, your request for relief is denied.
All right. Thank you, Your Honor.
Thank you. That's all I had on it.
Yes.
Right now. HP foreclosure solutions versus all occupant.
Good afternoon to you and your staff, Judge Simpson. Attorney Paul Spaniello, P72366 on behalf of the plaintiff.
Any occupants?
I'm here. I'm sorry. I'm trying to unmute sorry, Mary Cheatham.
Okay, gotcha.
Okay.
All right, this is a termination. This is a motion.
This is Cheatham's motion to set aside a default judge, for what it's worth.
Did you get a copy of it, counsel?
I had to ask the court clerk, and they were gracious enough to email me a copy. Yes, I did.
All right, very good.
Thank you for asking.
Ma'am, what is your position on why I should set aside this termination?
I did not see the court document to come to what am I saying? Okay, so I did not receive in the mail the court date until like 3 days after the court date.
Okay, let me explain a couple things.
Okay.
There are two parts to that you would have to show this court.
Okay.
For the court to set this aside.
Okay.
All right. The first part of it being that you'd have to show good cause for your failure to appear, which I think you were going to get into. Okay. What I think is more problematic, I think, for you is you have to show this court that there's a meritorious defense to the claim of the termination.
Okay. So I had entered into a lease with them. There was some problems with the payment. I think I addressed that in my motion. I have been in contact a little bit with, I believe her name is Michelle from HP. And I believe that we could possibly come to an agreement to allow me to just extend my stay a little bit so that I can get everything out of here. I guess.
Who did you lease from?
HP foreclosures.
Is that right, counsel?
Your Honor, during the course of the suit, and I do have Ms. Shifter here if you'd like to take testimony, but Ms. Shifter attempted to work out a resolution with Ms. Cheatham to keep her in the property. There was an agreement that if a security deposit was tendered and first month's rent, that they would have this binding lease and that we would ultimately dismiss the case. As you'll see in Ms. Cheatham's unsworn narrative, I guess her money, her husband or spouse absconded with the money, so nothing came of it. My client had attempted to reach out to her on multiple occasions and was largely ignored, and we proceeded. So, effectively, there is no lease, albeit, we tried to work something out with her, but if I could finish.
Sorry.
This case was filed on December 9th. The redemption, I don't have it in front of me, expired late last year. And now we're here on February 20th, Your Honor. And there's still been no monies produced. So it's our opinion that there is no lease agreement. I mean, my client would not enter into a lease without that.
But I guess, was there signed documents of a lease?
It's my understanding my client did sign the lease, but predicated that the effectiveness of the lease on that payment.
Okay. So I don't have a copy of the lease.
Well, it wasn't a part of this action. It was something that occurred, my understanding, during the course of this matter. When I appeared at the first hearing, I was hopeful, and I even may have put it on the record that the parties.
Counsel, here's the problem with that argument. Under paragraph 5F, this action was maintained because of the expiration of the redemption period, but then specifically indicates no tenancy.
Correct, and there was none at the time that the matter was filed, Judge. I'm sure Ms. Cheatham will tell you, and my client representative will tell you, that after this was filed, they were trying to work out a resolution to keep Ms. Cheatham in the.
But then we get into the other issue. So you're saying this signed document, this lease, was entered into after this case was filed?
That's my understanding, yes, Judge.
Ma'am, is that correct, Ms. Cheatham?
Yes, if they filed it on December 9th, because I don't,
When did you sign the lease?
I did, sir. I did, Your Honor.
No,
and I am
when?
prepared.
When?
It was in January. I don't know the exact date. Might have been like the 9th or something. I'm not quite sure. But I am prepared to, I have the money to pay them at least the $3,800 today.
Hold on,
Okay.
hold on, stop.
Okay.
So after this action, both parties signed a document purporting to be a lease. I don't know how there is a conditional lease, but I guess that's what counsel is saying. And Ms. Cheatham is saying that there's a lease. I don't think, counsel, you can argue that there's no lease if both parties sign this document. I don't know how that works.
Well, if I may, just for purpose of nothing else, Your Honor, making a record, there's no consideration. I mean, my client could sign a lease, and if it's predicated, it's our position, it's predicated on payment, like most leases are. And if no security deposit was tendered, no first month, effectively, there's no lease.
No, that's not how tenancy works. I mean, if she's in the premises, you're in the premises, ma'am?
I am, Your Honor.
She'd been in the premises during the whole redemption period, my
I
understanding.
have not. I was in a halfway house. I just got released on January 30th.
Well, we were here before your January 3rd. We were here on January 9th, Your Honor. It was the first hearing, I believe.
Because I'm the executor of the will, so I've been like appearing for court hearings and things like that. But I've been pretty upfront about that. Like when I first came into contact with HP Foreclosure Solutions, that I had just been released from incarceration last July, and I've been in the halfway house since.
Okay,
Since
so
then
who's
until-
gonna send me a copy of this lease or this conditional lease or this thing that one side is purporting not to be a lease, but the other side is saying it's a lease? Because I don't even know how I begin to rule on this without a copy of it.
I don't have a copy. Ms. Cheatham or my client's representative, Ms. Shifter, I could have Ms. Shifter send me a copy and I could forward it to the court via email, or Ms. Cheatham, I guess, could. I'm sorry, I don't have a copy.
If I may, I'm sending that right now.
Okay.
Michelle Shifter.
I'm sorry, Your Honor.
Let me pass this matter.
Okay, thank you. And
Then it
then,
needs to be sent to my staff.
may I have the staff, can you put the staff's email in the chat if they don't mind?
Can you, she is putting it in there now.
I appreciate it.
Nicholas Schultz, Lake Rental versus Ken Olson II.
Good morning, Your Honor. For the record, afternoon, Salem Saman appearing on behalf of and with Mr. Schultz sitting in my office.
All right. And you are?
Ken Olson, Your Honor.
Courtney is not here.
No, she is not.
All right. All right, where are we on this case?
Well, Your Honor, the last time we appeared for the pretrial, I think the only thing that Mr. Olson said was he didn't agree with the amount of rent that was owed. I have sent to the court an exhibit. I emailed it a couple of days ago that references the amount that is owed. There is December, only 25 out of the 52 was paid, so there's 2,700 left for December. Then you got January 5,200, February 5,200, which is 13,100 plus 1,275 in late fees, brings the amount that's owed to 14,370.
Late fees are how much?
$25 a day, Judge.
That's illegal. That's liquidated damages. That you can't charge $25 per day late fee. Late fees have to be reasonably calculated on a rental property. They have to be reasonably associated with what it would cost for the collection of one's rent. $25 a day is not it.
Well, that's the understanding, the agreement between the parties, Judge.
Okay, but you know, counsel, people
I
can
do
agree
understand.
to illegal, they can't agree to illegal things.
Okay.
And nor will the courts enforce illegal things.
Okay.
Sir, have you seen this? This exhibit.
What is, I don't want to, I'm sorry. I didn't.
No, it's okay.
Okay, yeah, that's the first me seeing them, but yes.
Pardon?
Yeah, I didn't, that's the first me seeing that. All it is on the paper that was sent to me to come here was the 7,900 plus late fees is what was on there.
Okay, but part of your dispute was that the amount was not correct.
Yes, that's what, during the Zoom meeting last Friday, yes.
Okay. So when you look at this document I just shown you, do you still hold that position that this is not a correct amount?
Without the late fees, yes. I mean, I know what I owe.
So you would agree that the $13,100 is owed?
If that's without late fees, yes.
Yes, that's the $2,700 for December and then $5,200 for January and February.
Correct.
All right. Were you going to pay this amount or what were you?
My intention is to stay in home and pay the amount owed. I just was kind of again, when the money came out last week, what was told last week with all the late fees, I was really confused. And so my intentions are to pay the money.
When are you gonna pay it? Let me ask you, I'll put it to you this way. If it's 13 without the late fees, 13,100. When is your plan to pay that?
In the next few weeks.
When you say in the next few weeks, what date are you talking about? Because
before March 1st.
Well, you understand that it's the 20th today.
I understand. It's been a rough start of the year. Money's owed to me, and I
know, I hear.
So
you're telling me because you said the next couple weeks.
Correct.
In the next couple of weeks, I will be into March, but then you told me I'd pay it before March. I don't know what you're telling me. Two different things.
I understand. I'm gonna need a few weeks, at least 2 weeks. I can
But
pay.
then, if you have 2 weeks, there's going to be another 5,200.
Correct.
So are you planning on paying that amount too?
I have to have a place to live. It's not just myself.
Oh, I understand that, sir. Okay. Answer my question.
Yes, I plan to pay to the best of my ability. I plan to pay the money owed. I've never been in a situation. I apologize. So I plan to pay the money owed, or I'm gonna have to vacate the premises. It's one of the two things. I understand this. I've just been in a rough spot.
So I can do one or two things, counsel. Well, I don't think there's a dispute as to the 13,100. I'd grant you, I'm not enforcing the late fee provision because it's not a proper late on this account. So if it's 13,100 plus your cost, and I have your cost, give me, it's going to be 2. I have cost in the amount of $295. So you say you can have it in 2 weeks?
Yes.
Here's what I'm going to do. We're going to find after hearing that there's no tribal issue as to at least a portion of this. I will grant a judgment to the plaintiff in the amount of $13,100 plus their cost of $295, which would be a total amount of $13,395. Specifically, I'm indicating I'm not enforcing the late fees provision. To grant this judgment today, 10 days out is going to be March 2nd. And sir, what day I'm granting the judgment today, 10 days out. March 2nd would be the 10-day period. Are you going to have this paid by March 2nd?
That is the plan, Your Honor.
With the writ to issue March 2nd or 10 days from the date of signing. That judgment then does not include March rent, and you guys have to figure that out. All right, submit a judgment to the court. I'll sign off on it.
Good, Judge.
Thank you. Court calls the case, Kyler Johnson versus Amadalen Bailey.
Ready, Your Honor. Dawn Van Dusen, P69647 on behalf of plaintiff.
Judge Dominic Hamden, P67745, appearing on behalf of the defendant, Amanda Lynn Bailey. Judge, my client is also in the Zoom room.
Oh, there she is. All right. All right, where are we on this case, folks?
Your Honor, this matter it's regarding a trailer park, a mobile home in that park. My client, which is Kyler Johnson, owns the trailer in the park. Miss Bailey is his ex-girlfriend who is occupying it at this time. At this time, they did do a purchase agreement at one point, but I think I don't know where they got their purchase agreement, but Mr. Johnson would like to, already told her that he was going to rescind it. He does not live there at this time, but he would like the occupancy to happen. He has a loan payment on this trailer each month that it was agreed that she'd split half of it. She still hasn't made any of that. She failed to make payments October all the way to February on just that loan, which is her portion would be 500 of it, but with them not being together, it's a total of 1,000. The rent there on the lot,
because they're not together, her payment went up.
Well, they agreed they would split it at one point, but she hasn't made any of it. So we're not even asking for a judgment in this matter. We just want, as in a money judgment, we'd just like Miss Bailey to move out of the home, out of the trailer. She's changed the utilities into his name, into her own name. She has, so he cannot even get access to make sure payments are made. So she's actually only made payments starting in January for the utilities. So we're asking at this time that eviction of a 10-day order be granted to order her out of the premises.
Mr. Hamden.
Judge, the parties are subject to a purchase agreement. I don't believe you can just unilaterally rescind an agreement. I don't believe the purchase agreement provides for that. And my client is still wishing and desiring to go forward with that purchase. Second of all, my client is on the written lease agreement with the park. And so she has the right to occupy this space as the landlord to the property. So this is probably better characterized, Judge, as some form of a replevin case, as opposed to an eviction in order to retain his property back. It's not properly characterized as an eviction. It's probably better characterized as some form of a replevin.
Well, but I don't. Is the purchase agreement still in effect?
It did not have a termination date, Judge.
Your Honor, it also says the initial payment is non-refundable. It looks like she received this piece of purchase agreement, a copy of it, and that she filled it out. And it was part of the parks where if they were going to sell you one of their trailers. I mean, there was no down payment. There's no initial payment that it discusses is non-refundable unless the applicants are denied their credit and background check. Your Honor, this is not a normal purchase agreement and it has no closing date, no nothing on it. My client has rescinded 2 days after he signed it and said he does not want to sell it to her.
And again, my comment on that, Your Honor, would be that my client was prepared to close on it, had coordinated with a lender in order to do so, and he refused to go forward with the closing, and there is no provision in there which allows him to unilaterally rescind it. I think it's also worth noting, Judge, that the parties, and I'm sure Your Honor has put 1 and 2 together, at one point in time dated each other. And one of them was required to leave the premises because of a police report. And so what this appears to be is
oh, dear God. Is that true?
Your Honor,
hold on a second. No, I just need a very clear answer because this court has a very clear policy on that. And I'm just gonna say, because usually it's the male that's doing this. Is there a domestic violence complaint that was made?
Yes, Your Honor, it was made on October
And
23rd.
he was then required to leave the premises?
Correct.
I am not.
And Your Honor, there's no charges pending against my client. In fact, the charges were dismissed by Miss Bailey 2 days later after she made the complaint.
Okay. How long were they living together?
That would be something that my client would have to answer, Your Honor.
Judge,
Miss Bailey, how
We were
long?
living together 1 year.
Okay. All right.
Your Honor, I wanted to add something. I just wanted to say that the reason why of wanting to go back on the purchase agreement was because initially I had signed the purchase agreement, and the next day she was trying to falsely accuse me of, and call the cops on me for stuff that wasn't done and just falsely accuse me. So that was
So
why
you got mad and said, I'm rescinding the purchase agreement, blah, 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 blah. I hear it all. All right. So what do you guys want me to do? I am not issuing a judgment. Not today. And I'm assuming, Mr. Hamden, you want to file a written answer to this.
I do, Your Honor, and I think it would be helpful if the court actually saw the purchase agreement as well as the lease agreement.
Somebody attach it, because if the purchase agreement's there, but there's also another signed document between the parties, correct?
There's a purchase agreement that was signed between the parties, Judge. The other agreement was signed with the park landlord, to which my client is a tenant, as well as Mr. Johnson. They are both tenants from the park landlord standpoint. I will attach both of those to my written answer.
Yeah, that was going to be my next question. So under what theory is the plaintiff terminating the tenancy?
Eviction, he owns the mobile home that she is living in at this time. He owns the mobile home. He actually has a mobile home mortgage that he has to pay every month. On top of that, then they rent the property the mobile home is on. So the only thing they have a lease for is the property that the mobile home is on with that park. So all he has to do, and which he has already started doing, and is he has to go in and get her off the lease, which means he just has to do it.
If I went to a family court and deal with a divorce, that's not really a divorce, I would have done that. I don't know why I'm even dealing with this mess.
Because it's an eviction, Your Honor.
I don't know that it's a proper eviction, because I've got a purchase agreement for property that one is saying I got mad and I just rescinded it after I signed it. The other party is saying, well, I'm sitting in here and he's going to,
Yeah, the terms of this purchase agreement haven't even been fulfilled by her. She's already, at the beginning, she was supposed to give him initial payment, and that has never been done. So the terms of this purchase agreement are
but your client just said that's not the reason why he wants to rescind it. He wants to rescind it because he got mad because she was saying things. He just
Your
said
Honor.
that to me.
Yeah, she has not even made in good faith an attempt to go try to finance this trailer.
My client had it financed, Your Honor, and was prepared to close. And I'm looking at the purchase agreement, and I could be wrong, and I don't want to be held out.
You can keep talking. I don't really care. I don't really care, because if there's a purchase agreement, you're saying that she's not doing whatever. And okay, fine. But your client just told me that's not the reason why he rescinded. I mean, counsel, I'm just gonna let you know, because if there was a domestic violence accusation, this court has been very consistent with its files. If there, with a police report filed, whether it's carried through or not, the court is gonna be very reluctant to evict someone who may have been a victim of domestic violence.
I
And
understand. that, Your Honor, but in this-
I'm getting the sense that that's the reason why the purchase agreement didn't go forth. That's the reason why everything is now being sort of couched as this eviction and this is my property.
But Your Honor, this could also be a reason how she gets him out of the home. She knows if she calls the police, makes false allegations, that he has to leave the premises. There's a reason it got dismissed 2 days later.
Well, you said she did it.
Well, she did. She went and, she made the allegations to get him out of the house. When he said, well, I'm not going to sell you this property anymore, then she says, I'm going to go dismiss the charges.
Mr. Hamden, how long do you need to answer?
Monday, Judge?
Pardon?
Monday. I'll get it going over the weekend. I actually had intended to get it going earlier this week, but my judicial secretary called in sick and everything was fine. I had no problems whatsoever, but I didn't get it done. So.
All right. Defendant to file an answer I'm going to give you a week to get an answer in. You're to file an answer by February 27th, 2026. And then I'll set this for an additional hearing. The way this is out, there's no reason for me to set this on a Friday. Give me a Tuesday that I can hear this.
The first Tuesday would be March 3rd.
March 3rd. I'll set this for, I'll call it a settlement conference. I don't know that that's going to happen. March 3rd, 2026 at 9 a.m. All parties are required to be present in person, including attorneys.
Thank you, Your Honor.
Thank you.
Thank you, Judge.
Court calls the case of Clark Road Family Limited versus Severin Claiborne.
Good afternoon, Your Honor. Attorney Samantha Sprague, 81931, appearing on behalf of the plaintiff.
I'm present, sir. Your Honor.
Pardon?
Oh, this is Severin. My phone was muted. I was trying to unmute it. I said I'm present, Your Honor.
Oh, she is present.
Yeah.
Okay. All right. Where are we on this case?
Yes, Your Honor. This is a non-payment. It's a subsequent hearing. We do show that currently there is past due rent in the amount of $5,019 and court costs the amount of $239.72 for a total due owing of $5,258.72.
Oh, cool.
How'd that happen?
I'm sorry?
When is her rent due, counsel?
Yes,
First of the month?
The first of the month, Your Honor. It looks like the last payment was received in November 5th of 2025 in the amount of $1,623. No rent has been received for December, January, or February.
I wrote something down very wrong, and I have to go back and look. But when we were here on the 13th, I think I was given a balance of $1,877.92.
Give me just a moment. I do believe there was a failure to recertify that may have, let me check that real quick.
Oh, Your Honor. I had went to recertify. I think, did you ever receive the note, the letter that I had wrote out for you?
Who?
With the dates and everything?
The note you sent me?
Yes, when I had came to turn in the last time when you had told me the paperwork like with Hawk and everything on it, and in the packet I had to fill out the paperwork and turn it into the court. I had also left a documentation of dates and issues and stuff that I had been having, and I had submitted that in November. I had never failed to recertify anything. I went to recertify in November, and I had wrote. They just called me probably like the day before court, or it was in that week frame. But they called me and told me that my recertification was never completed, which it was completed. And I told the lady of corporate, I said, I absolutely did go and complete that.
Are you talking about, ma'am, when you say a note, are you talking about an email that was sent?
No, it was like the print off. Like I printed off along with the paperwork that I had to submit. It was something in the packet that you told me to make sure that I submitted. It was like 2 pages.
Okay, all right.
And
fine.
then.
So.
Your Honor, if I may.
Yes.
I don't believe my client is on the hearing. If it's possible to get this rescheduled for 2 weeks out for an in-person, we'll confirm with my client regarding the amount and also speak with the defendant
Okay,
regarding.
but well, and let me just say this, counsel. My staff checked to make sure I didn't write something down wrong when a week ago. And the 1877.92 is the number you gave us.
Correct, Your Honor.
As always.
Was provided to us with the initial.
Right.
We do sometimes see that individuals lose their voucher, and I don't have any notes indicating that's what happened here, which is why we're respectfully requesting a 2-week adjournment so we can confirm with my client that balance amount.
Ma'am, do you have any objection to the adjournment in this matter?
Well, Your Honor, can I just say 2 things really fast? As far as me never recertifying, that is absolutely not true. I had went to recertify in November. Yes.
I can't understand that I can't do anything about that because I don't know if this balance comes from that or not.
Okay, well, well, the last thing I will say, and I'll leave it at this, is they called me saying that they lost my lease at one point and asked me to come back and re-sign. And then, like I said, corporate just called me like a few days before court and told me that I had never finished my recertification, which my mama taught me to document everything when I do it and put it in writing.
Okay.
So the
I
day
hate
that I
when I'm
document it, I
speaking
still
French
have.
because apparently you're not understanding me. I can't do anything about the recertification issue until I can see what the balance is.
Okay. That's fine.
Six is the date for me.
Yes, at 2 p.m.
I'll adjourn this matter. Well, I'm going to set it for, I understand what you're indicating, counsel. Why don't I set it for Friday? I just got to get a solid number. And then if I have to move it to a Tuesday, I'll do that.
Your Honor, I will be out of the office on the 27th. So that's fine as long as it's not next week.
Right. I was going to go to March 6th.
Yes, that's perfect.
So pardon?
I said, thank you.
All right. I'll adjourn this matter March 6th, 2026 at what time?
2 p.m.
At 2 p.m. All right. Thank you.
All right.